Recording in progress.
Oh, okay. I did it before once, but
I'm sorry, what?
We've got a couple of board members that are tied up in traffic with the storm damage, so we're going to hold off here for just a bit. Meeting of the Michigan Board of State Canvassers is called to order at 10:06. First order of business is public comment. Is there anyone, is Mr. Galanton or?
We do not have anybody on Zoom for public comment.
Perfect. A question, is Cheryl Huckins here? Ms. Huckins, you've indicated you wanted to talk on item 1, which is public comment, but I'm noticing that with your organization, are you really addressing? Do you want both public comment and comment on the summary, or? What I'd like to do then is to put you with the comments on the summary, and then what we'll do is we'll invite you up when we get there. Like a consideration of the meeting minutes for the April 18th, 2025 meeting. Need a motion to approve those?
So moved.
Second?
Support.
All in favor?
Aye.
Aye. And right away, we're at the consideration for the 100-word summary. Do you want me to read that? Do I,
Ask Adam to read that.
would you read that?
So I'll start off first by saying, obviously, I am not Director Brader. So I want to just say that Director Brader is out on leave for a couple of weeks. So I, in my capacity as Deputy Director of Elections, will be acting on his behalf. Relevant to the board, that includes acting temporarily as Secretary to the board. So I wanted to just make that clear so everybody is aware. So I can kind of start off first by just giving a quick rundown of the language that I drafted, if that's okay, and just kind of the why, what I was looking at, as well as read it into the record. So this is obviously a constitutional amendment. It deals with very similar topics as the petition that was addressed by the board at the last meeting. So what I first did was look at the differences between the two petitions. I looked at the difference between the one from the last meeting and this meeting as well, and noticed that there was very similar, if not exact, language between the two petitions, especially with some of the same topics. So in those instances, we had extensive discussion last meeting, obviously, about this. So I used the same language where the language was the same between both petitions. I used that in drafting the 100-word summary. So you'll see some of that reflected throughout the 100-word summary. I also looked at, again, kind of the same focus of what's changing for the voter. What are the things that the voter is going to see when they're when they're signing for the petition? What are the things that they're going to see in just their everyday life when the act of voting, for example, in this? So those are the things that I considered when I was drafting the 100-word summary, and I will read it. It is on the agenda, but the 100 words that I came up with were as follows. So it's Constitutional Amendment 2, add requirement to verify citizenship by showing birth certificate, passport, and/or other documents for voter registration. Eliminate affidavit alternative for those without photo ID when voting. Add requirement to provide photo ID or driver's license or partial social security number to receive or vote absentee. Require Secretary of State to review voter rolls to verify citizens and remove non-citizens using documents in government records. Prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show document to Secretary within 6 days post-election. Require hardship program for obtaining required documents at state expense, subject violations to civil criminal penalties, and that is 99 words.
Thank you. We have Mr. Porter and Mr. O'Keefe. You are representing Americans for Citizen Voting, Michigan?
That is correct. Good morning.
Good morning. I'm Kurt O'Keefe, so he's Mr. Porter.
Yes, we represent the sponsor of the initiative. Mr. O'Keefe is the treasurer of the organization. He has a few introductory remarks, and then I'd like to make a comment on the director's proposed language.
Yes, thank you for your attention, and thank the director and the elections people for working and fly-specking the language. We appreciate the hard work. I am the volunteer treasurer We're not here over past elections. I mean, there's been distrust of elections from the hanging chads in 2020, and it was Russian collusion in 2016, and it didn't get counted in 2020. So we are about the future elections, and there is distrust in our system in Michigan and nationally, and we do know that non-citizens did vote in our last election. So the purpose of this is just to set up a procedure that really puts the burden on the Secretary of State and establishing people who register going forward. People don't have to re-register. So that the real goal here is to restore the trust in our system, because it's really one of the things in our fragmented and polarized nations that is of concern. And I think Mr. Porter has.
Yes. So we thank the director for the summary language. We acknowledge that it's almost verbatim what the board worked through last month. As we recognize that, we recognize the context, that all the work that went into this. We would offer 3 friendly amendments to the director's proposed summary. The first and the most important, we think, is just language that has been left out, and that is, what is this proposal all about? If you had to summarize it in one sentence, it's that only U.S. citizens can vote. We think that by leaving that language out, it's not a fair and accurate representation of what the ballot initiative is. So we would suggest including that language in the very first clause, to state those 7 words, to provide only U.S. citizens can vote. We recognize that adding those 7 words would require you to find 7 words or 6 elsewhere. And we'd be happy to offer some suggested ways that you can do that. But I think the board's able to fly spec the rest of it and able to get it down to 100 words. The other amendment we would offer is just dealing with the sequencing. If anything I've learned being a lawyer, is location matters just as much in writing as it does in real estate. And the most fundamental, important part of the ballot proposal is requiring the Secretary of State to continually review the voter file to ensure that only U.S. citizens are voting. It's the very first portion of the ballot language that these citizens will be reviewing when they decide whether or not to sign the petition. So we think that should be sequentially the second in line in terms of the proposal. And third and finally, this is more of a trivial point, but we think it's important, the very last clause, it says civil or criminal penalties. We don't think that's a fair and accurate representation of the ballot proposal. We think the word enforcement would be a truer, more neutral way in order to convey how these are going to be enforced. And just practically speaking, it won't be a penalty in the criminal sense. It will be through civil injunctions and civil proceedings that these rights and responsibilities are enforced.
Before I cut it over, I have a question for you.
Yes.
You talk about not penalties, but enforcements. Don't you mention in there a 5-year penalty, a 5-year prison term?
Yes, that is part of the ballot proposal. That's correct. But we think, practically speaking, the most often way these rights and responsibilities will be enforced is through the civil system, not the criminal system.
Someone serving a 5-year penalty would look at it more as an enforcement than being penalized. I mean, that's hard jail time.
That's correct, yes. If you commit a crime, that's true. But just like any other crime that you commit.
I would invite you folks to,
Can I follow up on what you were talking about? The jail time. I also noticed that you are saying there would be no statute of limitations. Can you explain why? Like, for example, drug trafficking has a 10-year statute of limitations, but you're saying in this situation there shall be no statute of limitations? Why?
That's the policy decision that the voters can decide on whether or not to have. It just allows for greater enforcement of the rights and responsibilities that would be enshrined in our Constitution.
I understand that. My question is, what about, well, okay, that's fine.
If I may make a response, just in these type of situations, it may take a long time before something is discovered. It's not something that's regularly investigated. It's not reported as a crime when it happened, like if someone is attacked or assaulted or there's a drug crime, you know the crime's been committed and law enforcement is looking for the people. And these type of situations sometimes may not arise until later on before you actually find out that there was an offense.
Yeah, I didn't expect to agree with you, but I do, and that the ballot language, which has been drafted for our consideration, does not accurately state that no U.S. citizen, that only U.S. citizens can vote. And I think that that is the most important part of your proposal, apart from the criminal penalties. So I think that that should be front and center in the proposed language. Mr. Fracassi said that the proposals are very similar, but in fact, they're dramatically different. I think you would agree.
There are
That
some
your
meaningful differences.
proposal says that the Secretary of State has to verify everyone's citizenship, has to put in the qualified voter file whether, when, and how citizenship is verified, that has to also be on the precinct poll list, right?
That's correct, yes.
And that if the Secretary of State fails to verify the citizenship of more than 8 million people, anyone whose citizenship is not verified cannot vote a regular or absent voter ballot.
They can be challenged, yes.
And not that they can be challenged. What your proposal says is that if their citizenship is not verified by the Secretary of State, they have to vote, excuse me, a provisional ballot, which means that their ballot is not counted. There could be, it seems to me, because of the burdensome nature of verifying 8 million voter registration records, that there could be hundreds of thousands, if not millions, of provisional ballots where your proposal says that the citizens who are voting provisional ballots have 6 days to come and essentially present their citizenship verification. And if I read it correctly, which I do, I read it carefully, it says that they would present that information to the Secretary of State, who has, I don't know how familiar you are with Michigan election law, but the Secretary of State doesn't have anything to do with provisional ballots. Those are in the custody of the local clerks, hundreds and thousands of local clerks in Michigan. So there's no way that people who are, who the Secretary of State has not been able to verify as citizens, there is no way that those people could make their ballot count. That's correct, is it not?
I don't agree with you on that, but I do, assuming all of that is true, I do think the director's summary language does still, with those comments, still accurately reflect fundamentally the ballot proposal, even with all of those, I would say, criticisms of the proposal itself.
So that, we will obviously be discussing how the language, which has been proposed by Mr. Fracassi, should be changed, if at all. But you would agree that the important part is that it precludes anyone whose citizenship has not been verified from voting a regular ballot.
Yeah, there's one important point, though. This is not retroactive, so it's anybody who registers after the date that this becomes certified. So
What? No, explain that to me.
It's only for people who register to vote after December 18th, 2026, whatever it may be. Now, there is a process in place for the Secretary of State to,
I went through this pretty carefully. And Section 8 of your proposal says, if the United States citizenship of a registrant, that's everybody who's registered, or an applicant for registration, is not verified by the program, that person goes on to say that person cannot vote a regular or absent voter ballot and would have to vote a provisional ballot. And that is applicable, that is retroactive. That is
I
for
agree with you on that, yes.
everybody who is on the rolls as of the date that this proposal would take effect. And that would
I agree with-
presumably be the beginning of 2026.
I agree with you on that point.
2027,
The
I'm
point I was making is for new registrants, this is going to apply prospectively for people who register to vote after December 18th, 2026. Yes, there will be a process in place the Secretary has to undertake in order to verify that those who are currently on the voter rolls are U.S. citizens or are not, and they have to take steps to remove those who are not U.S. citizens. Now, how long that process takes, I'm not sure of that. I don't think anybody is.
But-
However, it is.
Timing of it is, if I may, I think the dispute is, this does not require the Secretary of State to verify all 8 million before the next election.
Yes, it does.
So I don't think that it does.
I mean, I can read the proposal that you have here, and it says, all registrants who are not verified cannot vote a regular or absent voter ballot. They have to vote a provisional ballot. That means that I, who have been voting for decades, Chair Hauskamp, who's been voting for decades, not quite as many as I have, that means that unless the Secretary of State verifies our citizenship status, that we can't vote a regular ballot.
But that's, if you have a real ID, then your citizenship status has been.
I'm sorry, what?
If you have the real ID, driver's license.
No, a real ID does not verify citizenship. That was said last time, and I think it's very clear that it does not.
I do understand your point. That doesn't affect whether or not the summary is accurate or not. We still think that the sentence in the summary that says that the Secretary of State has to review the voter file in order to determine citizenship, that is an accurate summary of what the ballot proposal
Right,
does.
but what-
You are correct that there is going to be a process in place. There isn't a timeline on that, but we have every confidence in the Secretary of State to be able to carry out that responsibility and that duty as she's required to, or he might be required to, by law.
That perhaps should be in the 100-word summary then, that these are provisional ballots.
Right, and you would agree that this prohibition on anyone whose citizenship is not verified should be clear in the summary, would you not?
Say that one more time, I apologize.
I'm sorry?
Say that one more time, I apologize. I was reading the language here.
So, something that would say that this constitutional amendment requires the Secretary of State to verify citizenship is something that you would, and that anyone whose citizenship is not verified must vote a provisional ballot.
Yeah, it says that already in the summary. Clause 4 says, requires Secretary of State to review voter rolls to verify citizens and remove non-citizens using documents in government records. And the very next clause says, prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show documents to Secretary within 6 days post-election.
It does say that, but it's kind of buried. And when I looked at the difference in language from the one we drafted last time, or approved last time, I didn't think that it was clear that this verification requirement is dramatically different from the requirement that was imposed on the ballot proposal that we considered last time, which only required a provisional ballot for new registrants who had not provided citizenship verification at the time of registration, which is a big difference between new registrants and the whole population of registered voters in the state. I still don't understand what you're saying about not retroactive.
So I don't want to, well, let me just offer this then suggestion. In Clause 5, it says, prohibit counting ballots from voters whose citizenship hasn't been verified. You could perhaps add the 2 words by the Secretary, by Secretary, to make clear that we're talking about those who have not been verified by the
But that
Secretary.
means that my right to vote a regular ballot is dependent upon the ability of the Secretary of State to carry out this monumental task of verifying all of the citizenship status of everybody in the qualified voter file.
That is true, but it's also accurately captured in that sentence.
I'm sorry.
That is true, but it's also accurately captured in that sentence.
It may be captured in a very vague way, but I think if we're trying to get people who are being asked to sign a ballot proposal, that they should understand what it is that this does. And I'm particularly concerned about that because I know that there are two ballot proposals. We considered one last time. And these may both be out there. And I saw some media accounts that said the ballot proposals were very similar. And Mr. Fracassi unfortunately said the same thing. And they're dramatically different. And so I think it is important for anyone who is being asked to sign either of these petitions, and I don't think either of them are necessary, let me qualify that, but they ought to understand that your proposal is dramatically different from the one that we previously considered, in that this verification requirement may take away the right to vote of millions of people.
Well, I don't know that we know that, so I don't know that you can
But
put that
it's
in the
possible,
summary.
is it not? What if you have a Secretary of State who just says, I'm not going to do this?
We have to assume that our elected officials are going to do the
Then
job.
you're going to sue the Secretary of State, right?
You can. Actually, there are civil enforcement mechanisms, including a private cause of action for any election official who doesn't carry out their responsibilities under the new constitutional provision. So
Yeah, right.
I have to apologize, I was misinformed. I thought that the Real ID was a citizenship thing.
I'm
but
sorry,
it-
what?
I'm apologizing. I was misinformed. I thought Real ID, you did have to be a citizen, so which
You're
it
not
should
the
be that
only
way.
one. You
I'm
don't need
not
to
the only
apologize.
one. A lot of
No, but
misinformation. But to the
people
point
have-
of,
right.
isn't it the Secretary of State's job that the state of Michigan have accurate citizen rolls? Isn't it a requirement to vote in the state of Michigan that you be a citizen of the United States? There has to be a mechanism for doing that, and I don't think it belongs at the local clerk's offices. As you pointed out, there's so many, and there's many different sizes. So if the Secretary of State, that should be the focus. And it would be a defense to virtually anything to say, well, what if this person doesn't follow the law? I mean, that, we can't, I don't think we can base it on someone not following the law.
I understand what you're saying. I think for what, to kind of reiterate what Ms. Gurwitz is saying, I don't think the summary says for new registrants, and I think that's deceiving. And I think for me, that's where the confusion came in. It's not just for new registrants, or, I'm sorry, it seems to be for new people who are voting for the first time, or people who are registering to vote for the first time. And that, I think that's misleading, because it is also for those of us who've been voting for 30 years, that after 2020, whatever the date is you have in here, I could be forced to vote a provisional ballot if the Secretary of State has not confirmed my citizenship.
you have to read these two clauses in the context of each other. The first one says, require the Secretary of State to review voter rolls. So we're talking about people who are already registered to vote. And then the very next sentence says, if you haven't had your citizenship verified, you can't count your ballot unless you prove that you're a U.S. citizen within 6 days. So whether or not we agree with that policy or not,
Well, right.
it is an accurate
I
representation.
don't think it is. Can the Secretary of State do 8 million people before, what date do you have in here? My apologies, it's 2020,
2026 for new registrants, but it would go into effect. I believe it would go into effect at the beginning of 2027 were it to be approved. And it would then require that in any election after that,
the Secretary of State.
right, and it doesn't even give the Secretary of State any time to undertake this enormous task. Would you agree?
I don't believe that there is a time deadline for the Secretary of
Right.
State. It's a continuing
There
process.
is no time for the Secretary of State to verify 8 million. Actually, I think it's.
Well, I think, isn't it effective in the beginning of
I think it's
2027?
8 million, at least when I looked yesterday, it was 8,148,345.
I think
So-
if it's effective in January 27, that's 23 months till the next.
I'm sorry?
general- If it's effective January 1, 2027,
Right, January 2027.
which is 23 months before the 2028 election.
So.
I know there's some elections before that,
Oh,
but,
so you're suggesting that the Secretary of State should start now?
well, January 1, 2027, I mean, that would be
This
fine.
hasn't been passed yet.
We would, well, if it were all done, we wouldn't be here, right, so, already, so.
But she can't start now, because this
No.
has not been. So
Right.
we're talking a short time frame for over 8 million people. That's what I'm concerned about.
I understand your concern. It's what we're talking about, a hypothetical it's based on the assumption that the Secretary of State will not be able to do his or her job. And I don't think that you can accurately capture that in the ballot proposal when we're making assumptions about what the effect of the ballot proposal would have on the working of our, constitutional system.
We have had effects in ballot proposal, in the 100-word summary before.
But not one based on assumptions and speculation. And that's what this one is.
And I think just in terms of, there are differences from the other ballot summary, but I think that the goal and purpose of this summary and of this board is, does this summary accurately reflect this proposal, as opposed to, because this is before the board after the first one, there's no requirement that we have to point out what's different from the other one. I appreciate that arises, and that would be an issue which I don't think will happen if both are being circulated. But I think that that's just the focus is, we need a summary that reflects what's in this proposal as to what's not, as opposed to what's in this proposal that's not in a different proposal.
I would agree with you that there is no requirement that we specify how this proposal differs from the previous one. I just think we have to accurately describe what this proposal does. And it is a very dramatic proposal, very dramatic, and would have, I believe, a seriously injurious effect on the voters of Michigan. So I think that is something that needs to be front and center, top of the line in this 100-word summary. So that.
I mean, maybe one of the things is the absence of the provisional ballot language. There's something in here that just isn't clear to me what happens to.
I mean, you struggled with this just last month, right? The provisional ballots, things like that. And this was the language that you four came up with, unanimously agreed to. It's prohibit counting ballots. That's a provisional ballot. And it's just another way it's a plain way of saying that to people on the street. So I do think that that's captured here.
Do you understand how the provisional ballot procedure works in Michigan?
Generally, yes.
Are you a Michigan attorney?
I am, yes.
Yeah, okay. I mean, do you understand that the elections are run by local clerks?
Yes.
And they are the ones who would have provisional ballots?
Yes.
And there would be 6 days for people to cure that provisional ballot and make their ballot count. And your proposal doesn't say that the voter would go to the local clerk. It says the voter would provide something to the Secretary of State, which is impossible. I mean, that's only one problem, and a minor one, but how would that work?
I don't understand the question.
How would somebody confirming information about their citizenship status to the Secretary of State in this short period of time, 6 days, how would that help the person whose provisional ballot is in the custody of the local clerk?
This is not the only context in which the secretary is communicating with local clerks. They can transmit information back and forth to each other on a regular basis.
So the secretary so this information would be going to the Secretary of State, and she would, within this 6-day period, communicate it to the local clerks?
Would update the voter file, yes.
Right.
Yes.
I want to address one last thing that you said, how we, struggled with this in the last meeting. But your proposal is very different than the one we dealt with in the last meeting, whereas this is going to affect everybody. The one we dealt with last month does not. The one we dealt with last month only deals with new people registering to vote. This is very different. So that's why I'm struggling in a different way. I appreciate you telling me I struggled last time. This is very different.
I meant that this is a
No,
complicated issue.
but it was a
and-
different,
yeah.
I'm having a different struggle here in the sense of the provisional ballot is important to me here because we're talking about a bigger group of people. We're talking about 8 million people here. That's very different than the other one. The other one was only dealing with people who are newly registering. So that's one of my concerns here.
I acknowledge your concern, again, I sound like a broken record. I do think that that's
know
actually
you do,
captured by
but-
these two clauses.
I
And I don't
just-
know that
yeah.
we can improve upon it in a way that all four of us would.
And
I appreciate that.
I appreciate the concern with the practical effects of it, and I think we do have some advantage in the time frame in terms of so many people are voting early, where we don't have everybody.
sorry, what?
We don't have everybody voting on one day. We have, 40, maybe up to 50%, I think, the deputy director would know, are voting ahead of time, so there's more time than just a whole crush. I understand the dynamics of it. What you're physically saying is, the provisional ballot is in the clerk's office in Mayo, Michigan, and the secretary's office in Lansing, so how does this go back and forth? I just think there is a longer time period than just, it isn't just everybody comes on the day of the election with the provisional ballot. We're getting up to, I think it was almost 40%, and will probably be 50% in the next election. So there is more time to deal with it. There is less of a crush on the voting. Again, that doesn't have anything to do with the summary, but
So there's another question that I have, and that is, if this passed in Michigan, it would be inconsistent at the present time with the National Voter Registration Act. Is that not true?
I'm not aware, I don't know the answer to that
I'm
question.
sorry?
I don't know the answer to that question.
So the National Voter Registration Act does not require citizenship status to be, it requires that a person swear that they are a citizen, but it does not require that it be in the voter file.
Okay.
Isn't that true?
I do believe that is correct, yes.
So if this passed in Michigan, and Michigan citizens, in order to vote in Michigan elections, Michigan residents, to vote in Michigan elections, would have to have their citizenship verified in the qualified voter file. But to vote in federal elections, that is not a requirement. Isn't that correct?
Based on the information you just provided,
Yeah.
yes.
So that means that there would have to be two lists in every polling place. There would have to be one list for people to vote in state and local elections, and another list for people to vote in state, local, and federal elections. Isn't that correct?
If you conceive of it as not as a floor, but as a requirement, then yes. But if it's just a floor,
So that would be, it would certainly be an additional complication for people administering elections in the 5,000 and some.
I don't think that's necessarily, I think it would end up being litigated. The other thing
I'm
is,
sorry, what?
it would be litigated. I don't think it's automatic requirement that it's somehow, that it's inconsistent.
What do you mean it would be litigated?
I mean, whether there would have to be two ballots, meaning if you are, I don't see how someone who would, on the National Voter Registration Act, and there's no one who registers to vote nationally. The voter registration is all handled by states. If you are a citizen in the state, you don't need to swear that you're a citizen to comply with the Voter Registration Act. You've established you're a citizen. Also, it may be replaced before that. The SAVE Act is inconsistent with the current National
It
Voter
may be. The SAFE Act may
Registration
pass, right.
Right, so
But,
that's.
but if it doesn't, people whose citizenship is not verified in accordance with this proposal that you have would still be eligible to vote in federal elections.
Or you're saying if they sign the statement swearing that they're a
Right.
citizen.
Right, which
Yes,
is what they've been
technically, that
requested
would
to
be
do
true.
for decades. So there would have to be two lists. I can vote in the federal election, but not in the state and local election. And if it's an election which has both federal and
State
and state
candidates.
offices, then there would have to be two ballots, or a very complicated ballot which says, don't vote. I mean, yeah, I mean, the administrative requirements would be pretty significant.
Well, I'm going to go back with the speculative difference on that, because I don't know that someone who's registered and qualified under the Michigan, how many people are then going to, I'd say, I'm not going to do that and not vote in the state election, but I'm just going to go sign this statement and only vote in the federal election. There might be two ballots printed. I don't think there'd be that many people that
Right,
would.
there might be two ballots, right?
Yeah, there might be two ballots. I doubt that very many people would be using a federal different ballot, and I doubt that it
And-
would still be the law at that time. My speculation of the future is, by the time of the 28 election, that would not be the case. Whether the SAVE Act passed, whether that was amended to allow some
If
changes to
come,
allow
right.
stricter state laws. This is a national issue in a lot of different states. 8
Of course,
states,
it's a national issue, but you're bringing it in states because you haven't gotten it passed at the federal level. And so you're trying to have states do this citizenship requirement to vote. And if in fact it happens and there is not action at the federal level, then states that have this requirement are going to have 2 lists.
but this federal government also cannot dictate the requirements to vote in state elections.
Oh, they can. They can. I mean, that's what the SAFE Act is trying to do, is it not?
Oh, but it didn't pass yet, to your point.
I'm sorry?
It didn't pass yet,
I know.
right.
But you
the
just said
states
it
could-
can't,
the
but
state- No, it can't, no, because the constitutional amendment that said you have to be able to vote at 18. 18-year-olds could already vote in
I'm sorry, we're
Indiana.
having trouble hearing you.
Remember the constitutional amendment, if you're 18, you're able to vote. So that's in the U.S. Constitution.
Right.
But you can have a younger voting age.
I'm sorry, you can have what?
You can have a younger voting age. There's bills in California that have the voting age to be 16. That's obviously different from the federal law. So the states regulate who can register in state elections.
Right. But
So the
if-
SAVE Act doesn't, if the SAVE Act passes, then you have states, well, if they don't line up. I mean, the SAVE Act is not going to control who can vote in a Michigan election. The way that they're trying to do it is with a funding thing, and they're saying if the states don't change their state law to make this citizenship requirement, we won't give them any money for their elections.
Right, but talking about the SAFE Act, which is something that might or might not happen, does not address what impact this proposal would have on Michigan elections now. So if this went into effect, there would be 2 lists. In the absence of federal action, there would be 2 lists.
I think
And
the answer.
people would have one right to vote in federal elections and a different voting right for state elections.
I think the answer there is that's a maybe.
I'm sorry?
That's a maybe. What you're hypothesizing is a maybe based on what may happen in litigation in terms of the inconsistencies between federal and state law, and we don't even know what those inconsistencies would be. The question, though, before you is that something that needs to be memorialized in this summary? And I don't think we can because it's a contingency. We
100
don't know.
words, really, it's hard to convey the momentous nature of your proposal in 100 words. That I would agree
Agreed.
with.
Mr. Cordes, do you have any comments?
Not a ton, other than the fact that I think that, as we looked at last time, obviously these are different. However, even in the last one, the Secretary of State was gonna need to put mechanisms in place to ensure that our qualified voter records were checked for citizenship. So I think that, we determined, or not necessarily determined, but there was enough evidence, in my opinion, at the last meeting that the states do have tools at their disposal to accurately ensure that the people who are on our qualified voter files are citizens. So I do want to just make sure we mention that. I understand that it's a large undertaking, but I think that is the responsibility of the Secretary of State, and that they can accomplish that based on the information that I've heard at this meeting and in some research that I've done prior to this. So what do you guys consider to be the biggest changes between your proposal and the one that we looked at last month?
So there are several. We go into a little bit more detail in the types of documents that can be used to verify citizenship. I think last meeting, the description of the definition was a bit circular. I think we solved that problem by identifying the actual documents that can be used, and it accounts for the name change issue that we talked about last meeting as well. And then the other big difference is the enforcement mechanisms. It puts teeth into these rights and responsibilities in a way that the other one doesn't. And I think, again, but that's been accurately captured with this new summary that adds that clause to the very end.
And Also, and it is a very big issue to try to put to 100 words. Part of the other proposal leaves to the legislature will enact laws to implement this. So even if you're voting for the other one, it's still even open-ended, well, what exactly will the legislature be doing? And part of what makes ours more complicated in terms of a short summary is, it's all in here, it's all of the Secretary of State. There's no, whatever the legislature does later to implement any of these provisions.
Right. Any questions before we,
Thank you.
you're not going anywhere, I trust, so. Mr. Brewer.
Thank you, Mr. Chair. My name is Mark Brewer of the law firm of Goodman Acker. We are legal counsel to promote the vote action, which is a ballot question committee opposed to the Americans for Citizen Voting - Michigan proposal. I have written testimony, which I'll submit, Mr. Chairman, but the basic point, and I've heard it here already this morning, that we've been making in our submissions prior to this meeting, was that this proposal is not remotely identical to the one you signed off on last month. For the reasons that have been articulated here this morning. And frankly, this proposal was clearly written by somebody who doesn't understand Michigan election law for a number of the reasons that have been pointed out already here this morning. Let me focus in on the summary, because that's what you're here to discuss. The first sentence of the summary says that citizenship has to be verified only for voter registration. My colleague said, well, the first sentence is the most important thing in the summary. I agree. That sentence is misleading. It's wrong. Because as has been pointed out, this applies to all 8 million plus currently registered Michigan voters. It does not simply apply when you register to vote. It applies to that plus everybody else who's already on the rolls. So that first sentence is incredibly misleading. The fact that later on, buried in the summary, are a couple of things that actually contradict that first sentence doesn't help. It's not up to the voters to try to sort this out. They need to see, and they're required and have a right to see under the statute in clear language, what is the purpose of this? And the purpose of this is to require every currently registered voter to have their registration verified. Let me add to the factual discussion that you were having in terms of the logistics of this. Michigan will have municipal elections in 2027. So it's not the Secretary of State's going to have 2 years. He or she will most have a few months before elections start occurring. In early 28, we're going to have a presidential primary in which millions of people on both sides of the aisle will participate. That's barely a year after this proposal takes effect. So I know, again, this is not about the substance of it, but I'm just adding to the discussion you had this morning about logistics. But that reinforces the fact that the voters have a right to know that every registered voter is going to have their citizenship verified. ASAP, frankly, the way this works. You don't have to use the word ASAP, but don't minimize it by saying, oh, the Secretary of State's got 2 years. He or she will not have 2 years to perform that massive task. And if it's not performed, you're going to have hundreds of thousands, if not millions, of provisional ballots in the state. People who are citizens, who've been voting like you and Ms. Gurwitz, who've been voting for decades, are going to be disenfranchised. And millions of other people like you. That needs to be disclosed right up front. I have an alternative summary, Mr. Chairman, which I'd like to tender, which I think corrects that error in the first sentence and makes enough other changes so that's still 100 words. May I share that?
You may. Do you have copies for us as
Yes,
well?
I have copies for everybody.
Mr. Brewer, would you like to read that?
Oh, certainly I can read it. Constitutional Amendment 2, add requirement to verify citizenship by showing birth certificate, passport, and/or other documents for over 8 million currently registered voters and new registrants. Eliminate affidavit alternative for those without photo ID when voting. Add requirement to provide photo ID or driver's license or partial social security number to receive or vote an absentee ballot. Require Secretary of State to review voter rolls to verify citizens and remove non-citizens using documents and government records. Prohibit counting ballots from voters without citizenship documents and photo ID unless voters show documents within 6 days post-election, and require a hardship program for obtaining required documents at state expense. That's 100 words and corrects the inaccuracy of the current proposed summary's first line.
I would open for questions. Ms. Cummings, would you like to?
Mr. Brewer, I'm just reading over did you include, I know it's right here, sorry. I'm concerned about the criminal and civil charges. I don't know if that's included in yours.
It is not.
Okay.
Those are the words we struck in order to have enough
I
words
understand, yeah,
to accurately describe the most important aspect of the proposal.
yeah.
Have you considered a way to add into the 100 words the fact that this would create different lists for federal and state elections?
I think you certainly could with some editing,
It's a
Ms. Gurwitz.
challenge, but I'm sure you're up to the challenge.
Well, thank you. But again, our focus was these 8 million voters and what's going to happen to them.
Yeah. It's just that, as I said, there's so much in this that 1,000 words would be difficult, but 100 is.
Right, but again, I think the fundamental principle is this is not at all identical to
Right.
last month's. And the press reports are erroneous. The current draft proposal, with all due respect to the acting director, is not accurate. It's not identical.
Mr. Brewer, your states here that to verify citizenship by showing birth certificate, passport, or other documents for over 8 million currently registered voters. But the process still starts with the Secretary of State's office doing a verification program, correct?
Yeah, that's what it says. But again,
But your states that citizenship by showing birth certificate, passport, or other documents for over 8 million currently registered voters, I read that as I have to, as one of 8 million registered voters, that I'm going to have to go provide that. But that's not necessarily the case.
well, if you want to add the word Secretary of State in there, that's fine. But again, within 100 words, we thought this was the substance of it, that they have to be verified in order to be able to vote. I appreciate your point, Mr. Cordes. If we can squeeze some other words, we can put Secretary of State in there.
I mean, it very clearly states require Secretary of State to review voter rolls to verify citizens and remove non-citizens using documents in government records. So it's got that in there. So I think that putting in here that at the top that this affects, that it's a requirement that a birth certificate, passport. I mean that's misleading in my opinion. That we have to that 8 million people are going to have to verify their citizenship using birth certificate, passport, or other documents. I mean, I think that's very misleading.
Well, Mr. Cordes, we could take out or reduce the clause that begins to require Secretary of State and roll it into the first one. I mean, even the supporters of this proposal think that the first sentence has got to disclose what this does, not bury it several lines down. So if you want to edit or eliminate the clause beginning to require, Mr. Cordes, and move that language to the top, that's fine. Again, there's just got to be disclosure that this applies to everybody. And that subsequent sentence doesn't say that. The opening clause we propose does.
I understand Vice Chair Gurwitz and her position on all 8 million people have to be verified from the get-go. Mr. Brewer, I understand what you're saying. Sadly, I think that part of the confusion here is that in an attempt to be exact in this proposal, in this petition, the folks that wrote this proposal have nailed it down so tight that the issue of the 8 million existing voters was somehow not taken into effect in the way it's been worded. I don't believe that 8 million existing voters would be held back from voting. The QVF would, the qualified voter file would be used to get by the hard spot here, I think.
The language of the proposal is very clear in subsection 1A. If the United States citizenship of a registrant
Right.
is not verified by the citizenship verification or documented proof of United States citizenship before they apply to vote, they can only vote a provisional ballot. They cannot vote a regular ballot, as Ms. Gurwitz has pointed out. It's crystal clear. I appreciate they may have tried to tighten it, but the effect of tightening it means that you're going to have to check the citizenship of 8 million people before they are able to vote a regular ballot again.
And when this came up at our last meeting as well. I think we asked elections, the process of getting, for example, a driver's license, the process of registering to vote today requires birth certificate. Is that correct? You don't need to have a birth certificate to get a driver's license?
So I am not 100% familiar with the driver's license side of things, but you don't need to provide currently a birth certificate to register to vote. Yeah. I think the birth certificate depends on the type of license you're getting. If you're getting, like, I think, but there's a whole, I can pull that document up again. There's a whole list of documents that you're able to provide in some sort of combination that the branches have, our branch side has put out, so I can pull that out. But it's not necessarily that you have to provide like that one thing. There's alternate ways that you can also provide your.
Are those alternative ways, are those also valid proof of citizenship?
If I may, Mr. Chair, you
As I-
discussed this
as I
last month.
understood
All you
that-
need to be is a legal resident of Michigan
Right,
to get a
it-
driver's license. You
that
do
was-
not have to be a citizen.
That was the clarification that we had last time. So legal residents, whether they're green card holders or here on
Work
some other
visas,
basis,
student visas.
they can get driver's licenses. And so while the driver's license file may have the requisite information, it does not necessarily have it.
I've read this too, and this was in the last one too, is as the Secretary of State goes through this verification process, this is, I think, similar to the last one, where if a voter's citizenship couldn't be verified, they get notification. I think this says within, 7 days, they get a notification. So that would give them time ahead of an election to correct this with the Secretary of State's office, correct?
Depending on where they are in the queue, if you're the first person, that's great, Mr. Cordes, but if you're the 8 millionth, that may be the day before the next election.
I don't see anything that gives people, I'm sorry, where are you reading?
This is our section 3.
Okay, now, Section 3, I thought just said that if the Secretary of State determined, based upon an individualized submission or investigation, that a registrant isn't a citizen, then they have 7 days.
To correct or to
Then the Secretary of State has 7 days to send that person a notice, and the person has
Their
45
removal, right.
days to
Yeah,
correct.
to correct.
But this is only, this is in the situation where the Secretary of State has some reason to believe that the person is not a citizen. I don't see anything in the proposal that requires the Secretary of State to communicate with voters about the inability to verify citizenship. That would be something that would certainly be useful if people knew in advance of elections that their citizenship, that the Secretary of State was not able to verify their citizenship, and thereby giving them the opportunity to do so. But it's not in there, and
I guess I'm confused. The way that I read it is if they are verified, then they're fine, they're left on the list. If they're not, they're gonna be removed and they'll receive this documentation and then have, an opportunity to
no,
correct it.
I think that only occurs
The first,
if the Secretary of State has reason to believe that they're not a citizen. So somebody, and we've unfortunately seen this, that some people try to challenge voters by submitting lists. This person is not a voter, or is, is not validly registered, et cetera. But I only see Section 3 coming into effect if for some reason the Secretary determines that a person may not be registered and then gives the person the opportunity to prove to the contrary. And even this is different from the previous proposal that we considered, in that this is a little more draconian. The previous proposal said that somebody who was notified of a problem of inability to confirm their registration had 60 days from the date of receipt of a notification. This gives a person whose registration is questionable 45 days from mailing of a notice. So it's a shorter time frame, but it doesn't apply to the millions of voters who the Secretary of State doesn't have reason to question but has not been able to verify. So and if a proposal said that at a particular period of time, the Secretary was unable to verify somebody's citizenship and she was required to take whatever steps were necessary to give the voter the opportunity to provide that information, that would be a totally different proposal than we have here. And it would, I think it would be reasonable, but that's not what this says.
the default position under the proposal is that you cannot vote unless your citizenship is affirmatively verified. That's the default.
Yeah.
That was I believe, that was the gist of the request for the change in the first line, right?
Right. So I agree with Member Cordes that it should say require the Secretary of State to verify citizenship. And I think one of the things that's interesting here is that they say using local, state, and federal records. So recognizing that there are various sources of information. But I think it also to say documenting in the qualified voter file and precinct poll lists whether, when, and how citizenship is verified. Because this is also, this is so the precinct poll list is going to say, assuming somebody's citizenship is verified, that Member Cordes is a citizen according to, we verified this according to his passport, or somebody else is a naturalized citizen, or this person, Ms. Gerwitz, is verified by a birth certificate and a marriage license. All that information is going to be in the polling place? It's astounding to me. But that's what it says. It's so unnecessarily intrusive. I think it suggests to me a real lack of confidence in the Secretary of State. You have this job to do, and you better prove it, or we're going to sue you, which is what this is about.
Mr. Brewer, anything you'd like to add?
No, I'd be glad to take questions and help you redraft, but I'm here at your pleasure. Thank you, Mr. Chairman.
Dan Ziegler? And I haven't been asking this, but would you spell your name, repeat your name and spell it for the clerk? Thank you.
Thank you and good morning. Thank you and good morning. My name is Dan Ziegler, Z-I-E-G-L-E-R. I'm with law firm Dickinson Wright, and I'm representing the Committee to Protect Voters' Rights. My associate, Mr. Charlie Spies, sent the board a letter to the board late Wednesday. I have hard copies if anyone of the board needs it. But I wanted to come here just to concisely summarize that letter's 2 points, add a third point, and then try to answer any questions if I can. So as an initial matter, I just want to state what the board already knows, which is the legal standard to approve the 100-word summary is that be true, impartial, not prejudicial either for or against, that it apprise voters of the subject matter and the purpose of the petition, and that it be in plain common language so that it can be understood. Deputy Director's 100-word summary is pretty good, but because it omits a couple of key subject matter points, it doesn't fully apprise potential signatories of what this petition will do. So the first subject matter area that it does not apprise potential signatories of is a new power that the Secretary of State will acquire. This petition at Article 2, Section 1, Clause 7 says that the Secretary of State must decide, quote, whether the applicant's claim of U.S. citizenship is more likely than not true. And that's a new power. As far as I'm aware, no officer or agency of the Michigan government has ever been empowered to decide citizenship. It's always been about verifying citizenship. And it's important that this new power that the Secretary of State has never wielded is going to be in addition to having to verify 8 million voters. It's going to also be deciding the citizenship of people, which has formerly always been done by the United States government. The question is a person a United States citizen? That seems most properly before the United States government. But here, this petition would give that power to the Secretary of State, and that is a significant subject matter change that petitioners, or potential signatories rather, ought to be apprised of before signing it. The second large subject matter omission from the 100-word summary is that it creates two classes of voters, and this already been discussed, but it explicitly says it at Article 2, Section 1, Clause 5, where it says, if federal law allows, this requirement shall also apply to registrations to vote in federal elections. And what that gets at, if federal law doesn't allow, then it won't apply to federal elections, but it will apply to state elections. And as this board knows, Michigan elections have always been binary. They've been an on-off switch. If you're a voter, you vote. If you're not a voter, you don't vote. This petition would change that. It would create a second tier, 2 tiers of voters, where some voters vote in only federal, some voters vote in federal, state, and local. And that, in addition to being, a large administrative task for the Secretary of State, the county clerks, the election inspectors, it's also going to be a task for Michigan voters. Michigan voters will have to decide whether they're going to jump through the hoops to vote in federal elections or jump through those hoops and additional hoops to vote in federal, state, and local elections. So it substantively changes how Michigan elections have worked. And I believe only Arizona has a subset of voters where you have 2 different classifications. So we'd be joining, if this petition were adopted, we'd be joining a very small subset of states, 1 state, I believe, that has different kinds of voters. So that's an important subject matter change, and we believe by not including it in the 100-word summary, it doesn't properly apprise and give notice to potential signatories. The final point is also been batted all around already, which is this criminal penalties clause. And this, again, to put it mildly, is highly unorthodox. I'm not aware of any state constitution which includes specific criminal penalties, much less specific criminal penalties that go against both the potential voter and election officials, election workers. So this would be novel, as far as I know, in American constitutional law, that election officials and voters are facing specific spelled out criminal penalties. So while Deputy Director's 100-word summary does mention the criminal penalties, I believe it actually doesn't do enough to mention them, because this is this is a quite significant change, and under statutory law of what the 100-word summary needs to do, which is apprise of the purpose and content, and give notice to the potential signatories, they're not on notice of how unique this is, and that it applies to both voters and election officials. So with that, if the board has any questions that I can try to answer, I would be happy to.
Let me
Do
start
so.
from this side first. Mr. Cordes.
Quick question.
Mr. Ziegler, I have a question, and it's from the letter at the bottom of page 2, I believe. Let me see how many pages. Bottom of page 3.
Could I hold you for one quick sec? The letter that's being referred to here, I don't believe.
Oh, I apologize.
Would you,
Oh, he offered this.
I have copies.
He
I
offered at the beginning, yeah.
would you make sure the other councils got them? Thank you. Thank you.
Yes.
So it says at the the final paragraph of the page, if the petition's potential creation of a 3-tier voting system is not included in the summary, do you know what Mr. Spees is referring to, 3-tier?
He's referring to non-voters, tier 1 of voters, federal only, tier 2 of voters. So it's 3 tiers in the
Got
sense, as opposed to an on-off switch.
Got it, okay.
A question about this. You're saying that the Secretary of State is deciding citizenship. But isn't verification itself deciding whether the verification is valid? By verifying, doesn't somebody who says, yes, whatever information is provided to me, aren't they deciding whether that information is sufficient to establish citizenship?
Well, verification is confirmation of an already confirmed fact. Verification occurs after a decision has been made. So for example, if I've been issued a United States passport, that was a decision made by the federal government that I'm a citizen, I receive a passport. I still have to go verify that under this petition with the Secretary of State. But it's not the Secretary of State's role then to redo whatever whatever was done in order to issue me that passport. It's simply a verification that I have the necessary documentation. This would be a unique situation in which the Secretary of State is reviewing, I believe it's open as to what documentation, affidavits, other information the Secretary will review, and then makes a new determination for the first time, rather than a simple verification that I hold a valid passport, not expired, et cetera.
Doesn't the Secretary have to make some additional determination in the situation other than the passport situation, which I agree with you is easy? In the birth certificate, marriage license, whatever else is sufficient to establish that the person is the person whose name is on the birth certificate. That requires some, this is not a major point, but I just, Mr. Spees focused on this, and so it seems to me that the very verification process does necessarily involve some determination about whether the verifying documents are valid.
And they're certainly related concepts, but they are distinct. So I agree with you, there are similarities, and there might even be an aspect of determination. If I show up with the wrong passport, I guess you could call it a determination but it's really I think that's more properly saying it's verifying that the document is accurate, not necessarily verifying, that the underlying information the document represents is accurate. You're not redoing the process.
I do have one quick question. So I'm reading through this, and this specific language looks like it applies when documentation may have been lost, destroyed, or otherwise can't be provided. This isn't across the board. Is that correct, or am I?
That is my reading of it as well. It's a
It's in
significant.
it's in very limited situations where someone's documents are lost in a fire and can't be duplicated for some reason.
That's right. It would, not be in every situation. I don't know how many situations it would be in, but it's more the grant of kind of the base power where no state agency or official has ever had the power to decide citizenship. That's always been left to the
Doesn't that
federal government.
exist today? I mean, certainly there's cases today where someone can't produce documentation for something. How does the Secretary of State deal with decisions today?
So in terms of the registration piece of it, you don't have to provide, for voter registration. It's like your driver's license number or your last four of your social would count, like in that instance. So at the federal level, HAVA has specific ID requirements as well, but like that's another example that can kind of suffice.
You're really kind of splitting hairs here. We're not splitting hairs. You're really establishing a case where this is absolutely purely limited to the citizenship question, because the Secretary of State today certainly makes decisions about who someone is or says they are or what they are every day.
Right, as opposed.
You're simply, this is very narrowly focused on the Secretary of State.
Right. It's a narrow grant of power, but it is a very large power, and it's a power that's usually been left to the federal government, and is now kind of being transferred over to the Secretary of State to wield. And, whoever the Secretary of State is after the next election would have to wield that. And I think it's important to note, I don't think I mentioned, it's by a more likely than not standard, right? 51%. So whoever the Secretary of State is, they're going to be determining, deciding the citizenship of people who fall within this category by 51%, more likely than not.
Seems like that would be a very difficult point to put into a 100-word summary, even if it was the only thing we were putting in there.
It would have to be precisely worded, but
Do you mind if I can I visit one with you that's a little bit of a one-off? You mentioned the penalties
yes.
as one of your concerns. So I'm going to ask you to help me as an attorney. When I read the penalties and the fines and the jail time requirements of this petition, and then I also read the idea, I believe the idea is expressed here, that there are many ways that someone could be called out as and accused of not being a citizen, or an election worker accused of allowing someone not verified as a citizen to vote. And I know those two are a little bit separated in this petition. Should I not be concerned here that this is in effect weaponizing? I don't know another word to use. I mean, what I'm reading here in one portion here is as if my neighbor's in front of me and he's got someone with him and I don't think they're a citizen, but I saw them vote. We're stipulating potential serious liability, and with a little bit of, I'm trying to choose the words I want to use here, and it's not the correct word, but it almost appears as though there's a frivolous dimension to accusing people of allowing someone to vote who's not been verified, or someone voting who is not allowed to vote. I understand the need for the penalties. I'm just questioning why they're here.
Yeah, and this is why criminal penalties are included in no state constitution that I'm aware of. It's because crafting a criminal statute is a heavy duty because of the potential for prison time or fines. And it's something that the legislature regularly tweaks and amends to get it right. Once this is placed, if this petition is adopted and it's in the Constitution, it can only be changed by constitutional amendment. So if there's an issue, or even, take like if inflation goes up and the $1,000 fine becomes meaningless, there's no practical way to amend it. It's in the Michigan Constitution for all time. So this is why this is so highly unorthodox, and no other state has ever done this. You said weaponized, and I think it's, I might not use that word, but I'm not coming up with another one. I think that's fairly apt to say it sort of sticks out like a sore thumb in this petition.
The word was deliberately chosen because it is harsh, and so I apologize if I picked the wrong word. So if we take this around to the 100-word summary, and you have very specific dollars and very specific potential jail time assigned in this petition, once those are put into the Constitution, doesn't this become like a minimum sentence, a mandatory sentencing?
It would be in the Constitution. I'm not sure I can answer whether, you know, a judge, whether it would be required or whether a judge could have discretion to go down because it's never been done before. That would be a question the Michigan Supreme Court would have to decide, whether a judge has to impose these sentences because it's a constitutional criminal provision rather than the usual legislative criminal provisions where judges are well-equipped and they understand their discretion, and that's been very well litigated.
No, I understand the constitutional side of it doesn't change the meat of it, but when I read this, it seems like there's a very strong call here to enforce. If anything is broken, there has to be an enforcement.
That's how I read it, and that also goes to the very broad statute of limitations.
I'm wondering if that needs to be really more focused in the 100-word summary as well. Thank you. Just, anyone have any questions or comments? Mr. Ziegler? No?
No, that's all for me.
All right, sir. Thank you.
Thank you.
I'm sorry.
It's okay. You have all my sheets.
No, of your.
You're thinking back to the old days, aren't you? What I would like to do before we have a whole lot more discussion on the 100-word summary is, and we'll invite you folks up again, but I'd like to, we have some public comments here. And Cheryl Hawkins, now before you come in, when you come up, would you state your name and spell it for the court, and I would, or for the reporter, and I would also ask that you limit your comments to 3 minutes.
Cheryl Huckins, that's CHERYLHUCKINS, and I'm representing voters, not politicians. I am also speaking on behalf of the 34,000 residents of nursing homes in the state of Michigan. I am a physician, a certified medical director, and the president of Palt Med Michigan, which is the professional organization of clinicians that work in nursing homes. An effective summary should describe the benefits as well as the burdens of the proposal. This summary does neither. Therefore, we need to look at what has occurred with similar laws in other states. In Kansas, this requirement for having proof of citizenship for registering to vote has led to 3 illegal voters being denied the ability to vote per year on average. It has also led to 34,000 people being removed from the voter polls. In Arizona, 40,000 legal voters were removed, which was 5% of their registered voters. The summary before us should declare the benefits, which seem few, and the potential loss of voting rights based on the experience of other states who have implemented similar laws. Michigan citizens living in nursing homes or homes for the aged or long-term care in other settings do not have birth certificates or passports with them. We might think that their families have them, but many families live out of state, and many of our residents do not have families at all. We might consider these some of the hardship cases, but who is going to help them apply even for hardship assistance? Not the nursing home staff, they're overburdened. Many of our residents have difficulty using phones to contact their clerk or the state of Michigan. Many of them don't have phones, and many don't have digital access. Has the Americans for Citizen Voting inquired how many of our residents don't have birth certificates or passports? Have they looked into how many homeless Michigan citizens have lost their documents? Have they looked into how many people who've lost their homes to fires floods, or tornadoes have also lost those documents. If they have those numbers, they should be sharing that with us so we can weigh the burden versus the benefit of this proposal. And if they do not have those numbers, then they have not done their due diligence and are misleading the public regarding their ballot initiative. Thank you.
Thank you very much. Marie? I was going to brave that, and I did not.
It's been my life since school.
Good morning. If
Luckily,
you
I
would,
didn't change my name.
if you would give your name and spell it for the clerk?
Sure, my name is Marie, and the last name is K-N, as in Nancy, O-E-R-L. There should be an umlaut in there somewhere, but I don't know
Should
where.
be, yeah. And you have 3 minutes. And I'll
I have
just
3
kinda
minutes.
wave you when you get there.
My name's Marie, as I said, Marie Cannerl. I'm a resident of Dexter, Michigan, and I'm a volunteer with Voters Not Politicians. I'm here to express my concern that this 100-word summary is prejudicial and misleading in the following ways. It doesn't make clear that all voters, including lifelong voters like my 87-year-old mother, will be subject to citizenship verification before voting and could be removed from the voter rolls if the Secretary of State or election officials don't have all of her documentary proof of citizenship data in their records. Not all of these records, as we discussed, are in state offices. In fact, the real ID versus enhanced ID, I just took my mother down to get her birth certificate down in Detroit, had to go to the Wayne County Vital Records Department with her wheelchair in a torn up street, and then proceed to take her to the Secretary of State and bring these things. So it is a arduous process, and she's lucky to have kids who can do it. The summary does not, regarding absentee ballots, the summary doesn't make clear that requiring voters to provide personal information with their absentee ballot can threaten the secrecy of their ballot or how their identities will be protected. AVBs have verification on the outside of the envelope, and providing this information could subject voters to identity theft and make our most vulnerable citizens, seniors and disabled Michiganders, justifiably afraid and possibly less likely to vote if they're unable to do so in person. It doesn't indicate whether Michigan voters will still be able to apply for their absentee ballot online. And it doesn't specify how the added absentee ballot requirements will affect permanent absentee ballot roll that a majority of Michigan voters passed in 2022. Provisional ballot delays will just fuel disinterest or distrust in our system. The 6-day provisional ballots, it's not going to alleviate it. And I would like to make sure that indeed the penalties are indicated in the 100-word summary. I think that's really important for people to see. I worry it's going to have a chilling effect on people helping out at the polls as well. I've worked as an election worker, and I might be more anxious to participate. I'm going to close with the tagline that Voters Not Politicians has been known for and is just as relevant now as it was when our organization began. Voters should choose their politicians, not the other way around. Thank you.
Thank you. Linda Appling. Morning. Would you state your name and spell your name for the clerk?
Yeah. Give me a second here. My name is Linda Appling, and you spell it L-I-N-D-A, then a capital A, P as in Paul, another P as in Paul, L-I-N-G.
You have 3 minutes. I'll
Okay.
just wave to you when you get there.
Yeah. I'd like to say that due to circumstances beyond my control, i.e. some type of weather condition, all my stuff is on my computer in my house that I don't have any electricity to at this point in time, so please forgive me. All right, first of all, I'd like to say that in terms of looking at this, it requires unwarranted documentation in terms of Michigan. Michigan, my home state, has had few, if any, cases of non-citizen voting. I mean, nobody has come up here and indicated how many cases that we've had. And as near as I've been able to determine, it's been virtually none. It is already a non-issue. And I also like to state that already, as has previously been stated, non-citizens, it is illegal for non-citizens to vote in Michigan. And additionally, it is difficult to obtain a birth certificate or passport or other documentation. This can be especially true if you're from another state. And as for the state of Michigan, I did call to try and find out how long it would take to get a birth certificate. Oh, about 20 days in terms of actually mailing me something. Now, I feel that this particular rule, it discriminates against women who traditionally change their name when getting married. This means the name on the birth certificate will not match the driver's license. Thus, women will have to have additional pieces of paper to validate their citizenship. And here I would like to say that many women have been married more than once, some 3, 4 times. I've got relatives that have been married 3 or 4 times. And they would have to dig out a wedding certificate indicating what their name is each and every time in terms of trying to prove their citizenship. It would be a track. I mean, you'd have to have a racetrack in terms of trying to figure out what their citizenship is. And I realize men don't have this problem, so therefore perhaps you have not found a way to address it, but it would affect women in terms of that. Additionally, you have the issue of those individuals who have been adopted, and you have a whole nother subsection of children whose parents may not have been married, and they may have changed their name at a later date, especially their last name. Many of this is not going to be you are not going to be able to track it, period. Now, I, myself, when I got married, I wisely decided that I wasn't changing my name. I was keeping my name. I don't know about everybody else, but my name was going to stay. I like being at the beginning. And I am now advising young women to avoid adopting or formally changing their last name, as that appears to be basically discriminatory against them in terms of how our society is moving.
Thank you for your comments.
That's good advice.
Okay. Oh, and one other thing, I am here for volunteers, not politicians in terms of that.
Before we deliberate 100 words or edit them, I would offer one more opportunity here to answer questions. Is there anything that's been said that you want to?
Oh, lots, but just briefly. I mean, the marriage certificates and the overriding thing is, I appreciate these over this, and women can't vote, and it's 8 million people, and it's not enough time. The poll that we took, 87% of the Michigan voters are in favor of it. The people are in favor of it. They're in favor of requiring that you prove you're a citizen to vote. Full stop. It was in 8 states last year. The lowest approval rate was 62%, up to 86% in South Carolina. So the panel is raising concerns that are not shared by the voters because the poll says it. It's only citizens, you have to prove you'll be a citizen to be able to vote. And there's already a process in here for lost documents. That's already been covered. Voters, not politicians. Yeah, we're for the voters. We want the voters to be able to decide this issue. And some of the comments are related to the substance of the policy as proposed and not to the just actual 100-word summary. again, arguing about whether nursing home people can vote or whatever. And of course, no, we didn't do any research on that. I'm not sure of all of Kansas and Arizona, but I know 40,000 voters is not 5% of registered voters. The point of how many voted is we don't know. When people commit the crime of voting illegally, they usually don't turn themselves in, with the exception of the citizen from China. I, by the way, did review the University of Michigan website registration where you register online, which does not even ask if you are a citizen. So that, I think we're getting off track there, and we're way off in the weeds when it seems to be purported that the Secretary of State was now given the power to decide who is a citizen. That is not happening. As far as the criminal penalty, it says up to 5 years. Nothing else has changed about law enforcement. It's illegal now. There were voting clerks in my county, Macomb, that were charged with doing something illegal. I mean, these things, it's a different, it may be a higher penalty, but as far as lawfare, it's already illegal to assist someone to vote illegally. It's already illegal to vote illegally. Those things exist. Whether they're prosecuted depends on the city attorneys and county prosecutors or U.S. attorneys if it's a federal crime. And the process is you report it to the law enforcement, and if they're not interested, it usually doesn't go anywhere. And then beyond reasonable, all the criminal protections are there. It doesn't change anything in the Constitution. As far as not mentioning whether you can do something online, no, the amendment is changing. It doesn't mention everything that is still there. So if it's not mentioned, it's not changed. Let's see. Sorry, I'm making these notes as people were talking. I think that's all the comments that I had. I think Mr. Porter probably picked up something that I missed.
Well, we're just happy to answer any questions that you may have following up on those comments.
I want to come back to, and I'm looking at this through the lens of crafting this 100-word summary here, and I kind of want to go back to section 3, Article 2, Section 1, subsection 3 there, where we talk about when they're going through this process. And again, it's my belief that there are tools that are available to allow the Secretary of State to go through this process. And could you walk through, could you walk me through in terms of if someone is removed from, if they can't verify citizenship for an individual and they receive notice that they're being removed, can you walk me through your interpretation of this?
So Section 3?
Yes, correct.
So that's when the Secretary of State is able to take a look at the voter on the QVF and determine, either through information that they have, that there's not enough information to determine citizenship, or there's information and it indicates that they're not a U.S. citizen. To provide that notification to the voter, and they have, I think within 45 days is what it is, to submit that proof to confirm that they are a U.S. citizen.
That process is a continuing, ongoing process, so it does not happen only 20 days before the election. This imposes, the point is to impose on the Secretary of State the duty to go through the voter rolls. And as that's being done, people are being notified as it's gone through. It's not all done just a week before the election.
Yeah, but that only occurs, this isn't something that requires the Secretary of State to notify people if they haven't been able to verify. I think it says shall, and in fact it says the Secretary shall remove voters from the list upon receipt of documentation or verified information. So somebody submits information to the Secretary of State. This isn't, and the Secretary of State is then required to take this action to give the person the opportunity to get back on the rolls, as I read this. It isn't something that says if the Secretary of State does not otherwise verify, she notifies people.
So I think I agree with you on the first part, that we're talking about two different things. If she receives information, either through her own internal sources or from somebody outside who initiates sort of an investigation, they make that determination. My reading of it, it's after the 45-day period expires. They are given an opportunity, some due process, to make their case for why the information is incorrect. That's the way I read it, yes.
So the person is, somebody submits my neighbor has a grudge and says, or somebody, you know, and I suppose this is likely to happen, quite frankly, most often with naturalized citizens, because there are a lot of attacks on immigrants. So somebody submits some information. I don't think that, you know, that this is a reason to believe that this person is not a citizen. Then Section 3 says that the secretary removes the person from the role and then gives the person a chance to get back on.
So I don't read it that way.
But you're just, I'm sorry, saying
Says
my
the
neighbor doesn't
secretary
look like it,
shall remove.
but you're skipping the first part. Reporting that my neighbor looks like an alien is not that's not documentation. It says when the Secretary of State receives documentation, so there's allegations or prejudice or things that exist, that's not documentation. Or just, we have an anonymous phone call, we're going to take somebody off the list. When the Secretary of State receives documentation, that's separate from the ongoing requirement of the Secretary of State to verify the voter rolls. So the Secretary of State is to verify the voter rolls, and when the Secretary of State finds can't verify citizenship, then notify the person, we can't verify you're a citizen.
Yeah.
You have to provide the verification. So again, this documentation, the things that might happen.
Right, but this is, Section 3 is not something that is applicable, as I read it, to the ordinary review of voter rolls. It's when something
Right,
additional happens.
it's in addition, it's two different things.
So there's nothing in your proposal which requires the secretary to notify any voter that she's been unable to verify their citizenship.
Well, yeah, that'd be sort of an impossibility.
I'm sorry,
That'd
what?
be an impossibility, right? If you, because.
It would be
yeah.
very difficult, but.
No,
but
to inform people that they haven't been able to do something, it's because you don't know what you don't know.
Right,
Yeah,
but.
I agree.
But if in fact the secretary has been unable to verify, then the person could be losing their right to vote even though they are citizens. And that's what I find particularly troubling about this proposal, among many other things. And you concede that it would be impossible for the secretary to communicate with people that they may be losing their right to vote. Or,
Right, for
or
this-
that their right to vote may be conditioned, you know, they may have to, within some period of time after voting, prove that they're a citizen.
I know that you are troubled by that, but the question before you, you have to sort of play this right down the middle. Does this accurately summarize what the ballot does? And the sentence, the fourth sentence, the fourth clause, does that.
Right. So, we've had fun with your 100-word summary. Now we need to become very productive here, and we have a number of ways we can approach this. Last time, we broke the summary into distinct sections, and we worked on a sectional basis. This particular approach, I think there has to be something that precedes that. Are you waiting for me? You're fine. Okay, good. What I'm hearing from different folks who've come up here, and what I'm hearing from our discussion is, a 100-word summary there may be pieces of this petition that are not reflected at all in the 100-word summary. If that's the case, we need to get those listed as to what they are amongst us. And then I would suggest that we go through section by section.
May I respond as well to a couple of things?
Please
That'd
do.
be helpful to kind of
Absolutely would help.
provide a little bit more structure as to why I did certain things and why I didn't do certain things as well. But I don't know if you want to, I did hear you say we want to take a break, so I don't want to jump ahead.
Do we want to break for a bit here? Do we need to break? Yes. You want 15 minutes, does that work? We will break for 15 minutes. The meeting stands in recess. We'll come back. All right. We need to work through the 100-word petition, and in addition to that, we're going to break for lunch at 12:30. So before lunch, we're going to hear how the 100-word petition was put together, item one. Item two is we're going to go through the list of what the board has heard that you folks believe or we believe needs to be in the 100-word summary that's not there. And number three is we're going to chat about the sequencing of the elements. And then we're going to break for lunch. Over lunch, we'll have a new suggestion will be put together for a 100-word summary revision. And then we'll take that up when we come back from lunch. Forgive my voice. Is that okay? Go forward. So, it's yours.
All right, so there's obviously a lot of comment, so I do want to respond to several things. So first, I want to clarify when I said about the petition being similar, what I meant is it's covering similar topics. I recognize that it's not, it is not similar, right? There are noticeable differences, there are several differences, and the ones that when I was looking at it, the main topic differences that I noticed when I was looking at it were first that the petition today, in addition to all of the other things that we talked about last meeting, the petition today has a provisional ballot process that I interpreted as applying to everybody, not just prospective residents. I interpreted that as applying to everybody whose citizenship is not verified by the Secretary of State. The second was creating this process of obtaining unattainable documents, as they use. So like we've kind of heard these documents that just the clerk's office or whatever happened, you are not able to obtain it. The third, it does really emphasize more on what is documentary proof of citizenship, documentary proof of citizenship. And then the fourth was this addition of criminal and civil penalties in the text of the constitutional amendment itself. So I focused in my drafting on that provisional ballot piece and that civil and criminal penalties piece because in while that documentary proof of citizenship, I can't say that phrase, there's a lot there that I was not sure could be captured in 100 words alone to say what are the different types and what the intricacies of it. So I tried to keep that more narrow and vague like we did with the last one at just saying required documents versus getting into any extraordinary detail with that. So I want to respond next to a couple of things throughout as well that I heard and kind of my rationale for what I did and why. As far as one of the comments, these are in no particular order as well. As far as whether or not the secretary decides who is or is not a citizen, I did not include that specifically because I thought that was a very nuanced issue that would be impossible to cover in 100 words. And to do that would be at the expense of a larger issue that would impact every voter on a regular basis, such as this provisional ballot piece, the ID piece that are in this, things like that. So that's really what I tried to focus on. With regard to the first sentence in my summary, the requirement to verify citizenship by showing birth certificate, passport for voter registration, the reason I kept that for voter registration in there, and the reason I had that in there is because the way that I'm interpreting the constitutional amendment is that, first, I don't believe that I'm going to rephrase this to avoid the double negative. I do believe that it applies retroactively. When I read the petition, I see in the text of subsection 5, registration requirements after December 18th, 2026 have to provide this documentary, there's the proof of citizenship, as I'm going to call it, when they're doing their registration. But for registrations that are currently in the qualified voter file, those registrations have to be reviewed by the Secretary of State. We do not necessarily, like as I read this, we may not necessarily require a document be provided to us because subsection 2 says that the Secretary shall make every effort to obtain and use documentation and data from federal, state, or local authorities. And it goes on to say, for example, motor vehicle license information. So I interpreted that as with Michigan, we're very unique in that our qualified voter file and the driver's license information is both housed under the Secretary of State. Most other states do not do that. We are able, at our own level, to have specific information that may meet that requirement. For example, if you have an enhanced driver's license, not a real ID, an enhanced driver's license, you have to provide proof of citizenship to get the enhanced. As I interpreted this could potentially allow us to just look at that and verify citizenship in that way. I could be wrong on that, but that's how I interpreted this, and that's why in that very first sentence I left the phrase for voter registration, and then coupled it later to specifically say, require Secretary of State to review voter rolls to verify citizens, et cetera. I'm fine if we want to kind of combine that to clarify that a little bit more, to clarify that it's for new registrants, current registrants, these are the requirements. I think that makes sense, but that was why I specifically left that. I don't believe that it is accurate to say that every single person would have to re-provide a document, especially for new or for current registrants, excuse me, because of that reason. In terms of saying the specific word provisional, the reason I didn't include the word provisional is because we've kind of gone around, even with other petitions as well, even in prior years. When it comes to the word provisional, I'm not 100% sure that voters know what the word provisional is, and that if you were to see the word provisional, would that suggest to the voter that they have to take some other step to do something before their ballot would count? So that's why I phrased it as prohibit counting ballots versus require voting of provisional ballot in that context. So that way it tells the voter, in order for your ballot to count, these are the steps that you're going to have to take. As far as the next piece, enforcement versus penalty, I specifically chose the word penalty based largely on two things. So first, when you're talking about criminal provisions, I've never heard criminal charges be referred to as like an enforcement mechanism typically, so that's partly why. But when you also look at the dictionary definition of enforcement versus penalty, penalty under the Oxford Dictionary is defined as a punishment imposed for breaking a law, whereas enforcement is defined under Oxford as the act of compelling observance or compliance. So I don't view a criminal, a section in the Constitution that says you are subjected to a 5-year imprisonment as an act of compliance or forcing compliance, as much as it's a punishment for not doing something. Same with that fine provision. The fine, the $1,000 fine and the 5-year, I don't view that as a mechanism to ensure compliance. That would be, for example, like a mandamus action in court or some other court action to compel compliance, whereas a $1,000 penalty and a 5-year sentence, in the words that they have used in this specific constitutional proposal, are phrased as a penalty for non-compliance, not trying to force compliance. So that was why I used penalty versus any other type. To the extent if we want to spell out those specifics to say like this would be $1,000 and or up to 5 years, I think that's fine if we want to spell that out as well. I'm fine with that. And then a couple of other things that I didn't include and my rationale for that. So the reason I didn't include discussion on the separate ballot issue, for example, as to whether or not we would have to have 2 ballots, would it be 1 ballot with federal election versus state and local election, is because it is too many unknowns. I don't know sitting here whether or not in 3-4 years, if this were to pass, if we would have 2 separate ballots, a federal only ballot versus a state ballot versus a both ballot, or if it would be a different way. I don't know that. That's something that has to be flushed out. So that was partly why I didn't include that. And then the other reason I didn't include, is for the same reasons why I didn't include anything about the poll lists or the language that they have in there that it must be generated from and consistent with the statewide qualified voter file, is because I don't know what the contents of that list would be that's different from what it is now. Like, the law already requires that the poll list be generated from the qualified voter file. That's the electronic poll book, and the paper version of the electronic poll book. That's essentially what this is, as I read that. And Michigan election law currently mandates that the poll book be downloaded from the qualified voter file using that information, or in the case of early voting, it comes, my point is it all comes directly from QVF currently. So that's why I didn't include that, because I didn't view that as much of a change for the voter, that the voter would see. And then finally, with subsection 3, there's a lot of discussion on like this notice provision. So the reason I didn't include that is very similar to other ones. It was a very nuanced issue that if we want to include it, I think we could, but then that comes at the expense of a topic that hits at every voter. So if we want to say anything like providing notification or something like that, we can. I didn't include it because this is one of those provisions that's very similar to the one we heard last time. There's still notice provisions in the prior constitutional amendment petition that we talked about last month. We didn't include some of that language, I think, for the same rationale with the 100-word summary for that same reason. So that's everything on my list. I know that was also quite a bit. I am happy to, so where we go from here, I'm happy to answer any questions. I think the one, what would be helpful as we're looking to redo or to adjust it would just to be what are the things that, you've heard my explanations, right? What do you want? Like, what are the things that you think need to be amended or added and things like that? So like we usually do, so.
So if we approach it that way, to my fellow board members here, and this is your opportunity, but I think one, if there's items here that we want to add into the 100-word summary, let's list those out. And two is I think we want to structure what order all of the pieces go into. So with that said, Vice Chair Gurwitz, would you like to take the first shot?
Right, so I think I agree with the ballot components that the fact that this requires verification of everybody's voting, citizenship status, needs to be front and center, and that it precludes voting where the verification has not occurred. I think that needs to be the focus of this, because the opportunity, obviously, to vote is important, and people need to know whether they're going to lose it. And I think that could be combined with the requirement that a new registrant provide the information. So just one sentence, like a constitutional amendment to require the Secretary of State to verify citizenship of all voters would cover both the new registrants and the existing registrants. I think I understand the importance of the criminal penalties. It's just so hard to put it in there and to have anybody understand what they are, but I think that needs to be in there. And with regard to the precinct poll list, this was problematic to me, and I don't know necessarily what was intended, but where they say that the qualified voter file has to indicate whether, when, and how citizenship is verified, and that the precinct poll list also has to be the same, essentially, as the QVF. That suggests to me that a lot of information is going to be in the precinct poll list that, it just might be really problematic. And I thought that was, similarly, I thought it was something that people ought to know. But anyway, other hand, I think we could say, eliminate affidavit alternative, blah, 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 for those without photo ID when voting, add requirement to provide photo ID or driver's license or partial social security number. That part, I think, that fits, and so what we need to do, I think, is to get to the point where we can describe accurately what this is doing with regard to both new and existing voters. So, and I'm really baffled by how to include something with regard to the criminal and civil penalties. I think it's a big issue, but very hard to describe.
That's why I left it the,
Yeah.
yeah, for that reason.
Right,
yep.
I don't know, saying it succinctly doesn't convey very much, but it would be hard to convey it otherwise, because we're limited, obviously, in how to describe a really monumental proposal.
There's a lot to put into 100.
Right, it is a serious challenge.
Member Cummings.
I mean, I would like to see it in there if we can. And
Yeah.
I understand what you're saying. I think the fact that it's the first time that there will be anything in the Michigan Constitution that has a criminal or civil penalty to it, I think is very important. But I don't think we're going to be able to say much other than including what you put in it. Subject violations to civil criminal penalties. I mean, that might be the most we can do. But I feel that's important to have in the summary.
The other one I guess I would add to that is 5 years is a long time. This isn't getting your hand slapped and going to pick up sidewalks for 90 days. This is a very significant, if you put it on par with other crimes in Michigan,
And no statute of limitations.
and there is no statute of limitations. And I think somewhere in here that has to be put in. But
Just adding and.
But I'm getting your input, not mine, so, do you have anything else you would like to see in here? Is there anything else in the petition that needs to be?
Not anything different than Ms. Gurwitz said. I do think we need to have up front that the fact that it's affecting everybody. The 8 million, I don't know if we list the amount, but that this is.
8,148,345.
No, because it's going to change.
Yeah, the only reason I wouldn't specifically say the number is because the second, so you print this
Right.
30 seconds later,
gonna
so
do
that,
that.
yeah.
8 million plus.
Mr. Cordes, do you have anything you'd like to add?
No, I have no additions. I am curious to see whether, when we talk about sequencing of this, whether we can, move up the Secretary of State review of the voter rolls to verify citizenship closer to where we have the requirements of new registration. That would be the only thing that I would say. But nothing that I would like to see new added to this.
I would only have one comment regarding the ad takeaway. I would agree with the petitioners that they had a very strong request to make that first sentence to provide that only U.S. citizens can vote. And I think that does factually state what this whole petition, that is the root of the entire petition, right?
It is, but isn't that already
Yeah,
true?
That is already true, so it's only.
So it's reflecting
Only
something
U.S.
that exists
citizens
already.
verified by the Secretary of
Oh,
State,
okay.
right?
Yeah.
Yeah.
We're not adding, we're not creating something new with this petition. We're simply modifying a process that's already in place and a law that's already in place. That would be how you would view that sentence.
Correct, yeah, current, both law both at the state and federal level already, prohibit or prohibit non-citizens from voting, and there are criminal penalties associated with that. So I would say that that is consistent with current law as it exists now. If it's something that's important to the board, I mean, we can find a way to add it.
No, if it exists now, there's no reason to, it would be in error to make this appear as though it were a new.
Arguably.
Your requirements are new, and the penalties are new, and the verifications are new, but the law itself is.
Correct. And typically when we've seen this a lot in recent years with election law requirements, especially when the last couple of petitions under election law where it's shifted existing statutory requirements to the Constitution. We've tried to focus on what is the change, just because again, you're limited with 100 words, right? It sounds like a lot, but it's not. It goes very quickly. So we've tried to focus on what are those changes that voters would see. And this has been both with 100-word summary for the petition as well as the ballot language. Like what's different, what's being done that's different. So like if it is a requirement where it's existing, but we're adding something new to it, like that's kind of what we have tried to focus on, at least in what the Bureau's presented.
All right.
So what's new is verification.
Correct.
And what happens if you're not verified.
So that's why I tried to focus on that piece of it. Yes. So I will say I think I have enough to, based off what you said, I see that somebody wanted, so I'm not trying to like cut anything off or anything like that, but yeah.
You would like to address us shortly, quickly?
Other state courts have interpreted the same language in Michigan's Constitution as ambiguous when it says every U.S. citizen, and then it follows, that's just a floor. It doesn't necessarily preclude non-citizens from voting. The case is Lacey versus City and County of San Francisco. The California court there said that was ambiguous and didn't necessarily prohibit non-citizens from voting. And so that's why we think it's important to add this language at the very beginning that says only U.S. citizens can vote. That's the rationale behind that, to respond to that.
I don't know what you're talking about. Honestly, I don't know any judicial decision that says that the requirement that you when you register to vote, you certify under penalty of perjury that you are a citizen.
I just cited you the case.
It's
Lacey.
What is the ambiguity?
Well, I personally would agree with you, but that has not stopped courts from interpreting similar language.
Or a court somewhere.
I cited, one case, Lacey versus City and County of San Francisco. But that's the whole point behind the ballot initiative, is to ensure that only U.S. citizens can vote, and you cannot vote.
By the Secretary of State.
Correct, yes. Thank you. Sorry. Didn't mean to.
Thank you. Right, it is 25 after 12. We will break for lunch and return at 1:10. That gives 45 minutes. Is that enough for Mr. Brewer? At your disposal, Mr. Chairman. Well,
I think he looks hungry.
I know, he looks hungry, but if we give you 45 minutes for lunch, does that give everybody enough time? Yeah. Stands in recess until 1:10.
I will say we do, just before everybody gets up, we do need to clear the room when the board leaves. I was informed by Senate Police of that. So we'll reopen it, but when we come back on the record. Thank you.
Are these for us to keep, or do we have to turn them back in? In other words, we don't write on them, right? I know, I thought that. Yeah, I kept mine pristine. I signed your name to yours.
I'm not signing any petitions, especially this one.
Adam, I'm going to bring us back into order while you're doing that. I'll bring us back into order while you're doing that. Meeting is convened at 1:14. We have a draft rewrite on the 100-word summary. We're just waiting for copies here.
Thank you.
Would you like to take the first? There you go.
Sure. Yes, I can read. So what I have drafted. I will say I already noticed there's at the top, we do need to clarify one thing, but it just involves the heading, not the 100 words itself. So, but after hearing everything, what I have drafted is as follows. Constitutional Amendment 2 requires Secretary of State to verify citizenship of existing registrants and remove non-citizens using documents in government records, and prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for those without photo ID when voting. Require photo ID or driver's license or partial social security number to receive or vote absentee. Require hardship program for obtaining required documents at state expense. Subject violations to $1,000 fine and/or up to 5-year imprisonment. And that is exactly 100 words. I was able to, so I'll kind of talk generally about some of the changes specifically. So I did bump up the very first line. I took that, I think that was the third clause before, I bumped that to the first, and then also combined it with the new requirement to try to match up that this is what's happening with the existing, what the changes that we have to do for existing versus what has to be done for new registrants. And then coupling that with that 6-day provisional ballot period, as we know that word to be. I was able to just rephrase a couple of things slightly to be able to get in the $1,000 fine and/or up to 5-year imprisonment. Using those words, I used those words specifically because it took it almost directly from the text of the proposed constitutional amendment itself. That's why I chose imprisonment specifically. And then that middle one, the eliminate affidavit requirement, that clause remained the same. That was previously the first one, and that's now moved down. And that is essentially, I believe, all of the changes to the proposed language.
Thank you for doing that over lunch. I I would open the floor to comments.
So I, I would change existing registrants to all registered voters. I don't think registrant is a very good word. But then I think if you say, excuse me, all registered voters, you don't need to say you don't need the phrase about new registrants. So, and one thing that I was thinking about before was the part about documenting. So if you take out the phrase about for new registrations require proof of citizenship, blah, 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 all the way up to eliminate, then you can add something about, which I think is important, about documenting proof of citizenship in the qualified voter file and precinct poll list.
So you're, just make sure I understand, you're suggesting take out for new registrations require proof of citizenship, that whole line, that whole phrase?
Right, because I think if you say to verify citizenship of all registered voters, that includes anybody who's registering in the future.
The only, so,
And I was, so, the phrase to document whether, when, and how citizenship is verified in the qualified voter file seemed to me really important. And maybe I'm reading more into it than others are, but it's a way, and I think, I think there was also some reference to in the proposal to the qualified voter file being a public record so that it would show this, and that all sort of fits together with the criminal penalty part, because they want to be monitoring every moment of the verification. So, you know, I'm doing more than just suggesting language here, but I'm sorry.
fine.
But I'm telling you why I think that part is important.
The only piece that I would say with that, I think that would require some other tweaks as well, because for new registrations, those may not come to us. And so if you're starting off that sentence to say requires Secretary of State to verify citizenship and go through all of that, new registrations, when they come in, will be handled, most of them lay at the local clerk level. So I wouldn't want to suggest that this is, trying to think of the best way to phrase it, like that it's somehow putting the registration piece onto the secretary, because that's still, one thing could come to the secretary, but you still as a voter fill out your voter registration form, bring it to your local clerk, and you'd have to show your local clerk.
But it's still the burden of the Secretary of State to verify.
That is accurate, yes. Yes, that is, yes.
So whatever they get from the local clerk, they have to be able to assure that the local clerk has gotten the citizenship documents.
Yes,
And,
that is
you know, we're just summarizing here, so the proposal says what it says about new registrants and existing registered voters.
Yeah, I mean, if that's something, if we want to eliminate that, we can, and replace it with something we can, if the board's okay with that. Yeah, so.
Can you say that again? So strike from where?
From or new registrations up through eliminate. Does that make sense to you that you put the new registrants and the newly registered voters and the existing together? Because the Secretary of State has to verify everybody.
I understand what you're saying.
Although I would also suggest, though, that what these folks are proposing distinguishes new registrations, right? Is that accurate?
I don't think it does, actually. I mean, they have to provide verification, but then they're in the file, and then the Secretary
Yeah,
of State has
to your point with how that reads, if they're just like if the Secretary of State has to verify even the new registrants, obviously you're leaving some, not necessarily leaving something out, but you're getting to the very end which is the Secretary has to verify regardless.
Has to verify everybody, so new registrants verifying themselves is sort of encompassed within the Secretary of State verifying everybody.
Yeah.
right? So, and then I would add, using documents in government records and document proof in the qualified voter file. I just think that's, I don't know how many words that is.
Could say some along the lines of using citizen-provided documents or documents, government records, because you're kind of combining two things that are happening.
But then you're throwing in the qualified voter file too, which is going to make everybody stop and wonder too. I don't know how you weave QVF into people presenting.
If I may make a suggestion. If you want to put something in there about documenting this and retaining this in QBF, I would not tie it with that first clause, just because that's already a very long, and it's already, if you're doing it this way, you are kind of combining two steps into one thing. And plus, you've got the additional third with the 6-day post-election. I would almost put it as an additional clause. If you're striking the 4 new registrations clause from semicolon to semicolon, I would replace that right there and say something along the lines of require documentation of the whether, when, and how citizenship was verified in the qualified voter file. And you obviously wordsmith that, but I would put it there if that's what you wanted. If that's the direction the board wants to go.
You have a logical split there already. You have new voter registrations require them to present proof of citizenship.
Right.
The Secretary of State is required to verify using QVF. Those to me are completely two separate.
I agree with that. That's why I put that in there, and I think that's for new registrations to have to show that proof, I thought was a bigger change for voters versus that was why I put that in there and had them separate.
I think it's factually relating it. I mean, Mr. O'Keefe, you were up here a little while ago. Is that a fair rendition? That you are asking the Secretary of State to verify citizenship, but you are also specifying new voter registrations will require proof of citizenship as presented with documents by the voter, by the registrant. So what you're saying is, but they take a different form when you weave them together. I think they change. It changes the.
Yeah, I took that, so in the constitutional amendment itself, it's subsection 5 that says no individual may be registered to vote in elections for state or local office after December 18th unless they provide documentary proof of United States citizenship.
So if we change existing registrants to all registered voters, and we've got 101 words.
There was.
eliminated words are single words, right?
That's what I was looking to see if there was any way to kind of tweak a little bit. You could get rid of just right at the front, the word "to" and just say require Secretary of State verify citizenship of all registered voters is probably what I would do.
Well, you could say eliminate affidavit alternative for voters without photo ID. Is that the same thing?
So the eliminate affidavit alternative for those without voting, photo ID was essentially the provision that would eliminate that alternate. In the Constitution, it would require all voters to show license,
Right,
their
so
license
eliminate affidavit
or
alternative, yeah,
photo
just
ID.
eliminate for voters without photo ID instead of, for those without photo ID when voting.
Yeah,
Say that one more time now.
yeah, so here it would be for, for alternative for voters without photo ID.
Oh, I see. Okay, get rid of it.
Yes. And that should
You could do that as well, yep.
Yeah.
So that's replacing two words with one.
It is, that was pretty good.
Oh, my gosh.
Some real expertise is being demonstrated. I do think that two.
You want that?
What do you think? Yeah, I mean, we require Secretary of State to verify or just verify? Or Secretary of State verify?
We can leave it in because you're back to leaving this in, right?
No, I think that's back to leave.
Yeah,
right?
we're at like a voting. I think so. Because this, we added one, right? But then this, we took off two. And then just change this, eliminate affidavit alternative for voters without photo ID.
You could put a semicolon after registered voters,
Okay.
and then
Take
you
out
could
the and.
remove the and put a semicolon after records.
Yeah, you could do that.
To verify all registered voters, semicolon, remove non-citizens using ballots, semicolon, then Calumet County ballots using been verified.
While you're busy removing words, let me ask you another question. Should we, in the spirit of the petition, which calls out U.S. citizens, should we, in the spirit of the petition, make that first to verify U.S. citizenship? Top line?
Yeah. You think it goes without saying, or?
Well,
you
I don't
think
know.
They
I
want to
mean,
say it.
You know, again, it's, is that important to what you're arguing? And again, I'm looking at your,
We're looking looking at your little badges and they don't say US. It's kind of assumed, right? You only had 5 words and not 100.
So it doesn't matter to you either way? Okay.
I might have a recommendation.
Okay.
So you,
I might have if I can kind of tweet, I'll read it before we print it.
okay.
I don't know why I'm talking that low. I should probably talk into the microphone. Just realized, sorry. Okay, let me pull it up. Okay. Okay. That looks right. Okay. So kind of hearing a couple of things. So, and I'll print this out if this kind of makes sense, at least initially before we print. But, so constitutional amendment to require Secretary of State verify citizenship of registered voters, remove non-citizens using documents and government records, prohibit counting ballots from voters whose citizenship hasn't been verified unless voters show documents to Secretary within 6 days post-election, document citizenship in voter rolls. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternatives for voters without photo ID. Require photo ID or driver's license or partial social security number to receive or vote absentee ballot. Require hardship program for obtaining required documents at state expense. Subject violations to $1,000 fine and/or up to 5-year imprisonment. Should that be years?
How many words?
How many words?
100 exactly.
Because I think, what was the part about documenting?
I put document citizenship in voter rolls. I didn't use QVF specifically, only because we use voter rolls elsewhere in that. And I think more people understand voter roll versus
I just
QVF.
think that it's important to have the word all before registered voters. Verify citizenship of all registered voters. Okay, so if we,
The only reason I took it out was just, I mean, we can,
right, but if
yeah.
we have, do we have a semicolon after voters in that first phrase?
Yes.
Okay, and then I think you could eliminate the "and" in front of prohibit.
I already did.
Oh, okay.
What if you did, in the, you just need one more word, right? So if you did, instead of at state expense, what if you did require state-funded hardship program, and that would get rid of at?
That would work.
Hyphenated. Yeah, required state-funded.
Yeah, that's a good call.
Role player, baby.
That is nice.
And if you could hyphenate most of that.
I'm sorry,
You
good
could
one.
hyphenate most of
Yeah,
that.
that's right. State-funded.
That's right. What does that make the new word count?
Takes it to 99, sorry, 99.
99, we can put another word in.
Actually, there is. I actually would add one more word, only in the one clause where it says to vote absentee ballot, I would add the word "an." So it says required to receive or vote an absentee ballot, and that would take us to 100.
To receive or vote an absentee ballot.
Yes.
Okay, I think in what, one point did you say, oh, right. When you have receiver vote, you need to have, yeah.
Yeah.
Okay, okay, well, that's,
So we took one out, we added one in, so you should still be at 100 words.
Yeah, that would be 100.
Can you print that and we'll circulate it?
Yes.
And then,
Yeah, I definitely would, I know that's a lot, so I definitely would recommend.
let's print it and circulate it, and then we can
Yep.
invite the parties back.
I think we're getting there with some ease, my gosh. Taking us less time than last time.
I like having the printer here. No, not you, no. I'm just going back to the days when we had to like run somewhere else to get a printer and it was awful.
Thank you.
Count one more time. I think either's fine. I don't really have a preference anyway. A year might be more accurate because it's referring to like,
Yeah, I think it should be 5 years.
year.
I'm sorry. 5 years imprisonment or 5 years? I think it's plural.
My initial thought with singular was only because it's like,
Waiting another year. Yeah.
Years or years?
It sounds like it should be plural.
I think it should be, yeah.
it should be plural. Plural. I would say I'm not either, so if we want to make it years. And that doesn't, yeah. Should we print it again?
No.
I don't think so.
My husband is a criminal defense attorney, and he always speaks in terms of months, not years.
I'll just say it when I read it again.
48 months.
I close this. That's what we'll send.
That's right.
Want me to read it again, or?
Good point. Like a jobs program for regular farmers. Does everyone has a copy of the new printout? Folks all have it?
To print them with an S in it.
say it on the record specifically, and then when we have it finalized, I'll put it in the distributor.
Yeah, the amended.
I would say, if you want to say amended, I wouldn't say.
I would like to give, before we vote, I will open the floor up if you would like to. If you would like to address this latest final version.
We have nothing to add. We thank the board for their work, and
You're good with it?
yes, thank you, yes.
Okay.
You're welcome.
Mr. Ziegler, you would like to speak?
Yes, please.
Go for it.
Thank you. So this, the board has just worked through this draft, and obviously I think it's an improvement. But I guess I would ask the board to again consider including this two-tier voting system. And the problem that this petition puts into the Constitution is that the Constitution will potentially be contrary to federal law. And if it is, and then we have this two-tier voting system, the very people that won't be able to vote in state elections, the only way to get this two-tier system out will prevent those people who can't vote in state elections from voting to remove the two-tier system so they can vote. It's kind of a catch-22, where without a mention of the possibility or the potential, which could very well come true, of a two-tier voting system, petition signatories will not be at all advised of that. And once it's in, it's kind of in and will be very hard to remove. So I would just ask the board to consider adding in that or something to the effect of that, just to apprise voters.
Two thoughts on that really quick. One is that that's a very complex model to present within this 100-word summary along with the rest of the items. It would be a complex item
Absolutely.
for a potential signer to contemplate. The second one is more of just a question. Is what you're describing with this putting the Constitution in effect in violation of the federal Constitution is what I thought I heard you say?
No, more so federal law.
Okay.
If the citizen verification requirements in this petition don't comport with federal law,
Oh, I'm sorry.
they couldn't apply to federal elections. So then we would have one track for federal elections and another track for just state elections.
Would that be something that would be subject to being dealt with in the court system if this were put on the ballot? I mean, is that outside of the purview of what we're doing here?
So I think that kind of gets back to the earlier point, like, short answer, I think partially yes. The reason, like, when I saw that is because it gets into that unknown for me. I don't know whether this would violate the federal law or the federal Constitution or even any other state provision or anything like that. And I can't sit here and tell anybody when drafting a 100-word summary that this will violate another provision, because I don't think I have that clarity. And as far as the tier, it's kind of the similar hesitation is I don't know what will happen. Like, I don't know only because the specific text of this proposal does not say that. That might be one of the things that happens, but it might not be. I don't know if we'll end up doing 2 separate ballots. I don't know if it will be 1. I don't know if it'll be 3. You know, so that's the main reason why I didn't include it. Again, if that's something that's important, then we can figure out a way to remove something and figure out a way to wordsmith it that voters would understand what that means. But I think that's a difficult concept as well to explain in general. So that's kind of what's my thoughts.
Yeah, you could, as you pointed out, you could add in a simple line that says creates a two-tier voting process, but that would be a misleading statement to put into the summary.
And I agree, and I would urge perhaps the use of the possibility of a two-tier system. Because the issue here is, it's sort of the complexity of the issue is equal to the importance of the issue and how permanently it's going to be locked into the Constitution. And I guess I would add just one point is, maybe I misspoke. It's not necessarily that this petition would put federally unconstitutional language into the Michigan Constitution. It's more so that there would be an inconsistency, and then the federal law supremacy clause would kick in. So it wouldn't necessarily overrule. The court wouldn't be striking down sections of the Michigan Constitution. They would just be holding that federal law will not allow this section to apply to federal ballots. So we need two separate tracks going forward, if that makes sense. It's not necessarily.
That sounds like a lot of litigation in the future.
But somewhere, I mean, the way that that could be addressed would be that the verification that is required here would be for state and local elections. But I'm not sure whether, in terms of informing voters, I don't know that they would understand the difference between requiring this for state and local elections and for federal elections. But that would address, I believe, the concern that you're expressing, would it not?
I think so.
Right.
Adding in language, keying in that if this petition is adopted and it's inconsistent, and then we have this two-track system, part of the issue is the people who only are allowed to vote federal elections won't be able to vote on the next petition that comes down the line, trying to remove language that created this two-track system. So suddenly we'll have a smaller subset.
That is bringing even further complexity to an already
I don't envy the
complex
board. It's a very
situation.
complex issue.
We
I
can't
just think it's important.
We can't hyphenate that many
You could
words.
hardly do that in 100 words.
Yes, give your name and spell it for them.
My name is Fred Zolik. I'm with Citizens to Protect Voters' Rights. The board was sent this document by the proponents of the amendment. This came in your packets at some point. Their proposal presumes that this federal-only system will exist. Under reporting, it says, our measures requires extra information about the progress of citizenship checking, including a breakdown between federal-only and all other types of registrations. They think this is the default setting, that we will have a two-tier system. They go on to say there's a state versus federal distinctions. We allow list maintenance activities for non-federal registrations to continue past the NVRA's 90-day cutoff.
Reading in
This is a document that the proponents
Oh, this.
sent to you last week.
Okay, yeah.
So they're telling you that their proposal has a two-tier voting system. It's not hypothetical or contingent. They're expecting that this is the new default.
Right, because they're expecting the SAFE Act is not going to get past the Senate, right. But, yeah, I understand that.
Okay, thank you.
That it's, thank you, that's really helpful.
Could you spell your name? Do you mind?
Oh, I'm sorry. You don't know how to spell it? W-S-Z-O-L-E-K.
Just as it sounds.
No, you're close there. Wait a second. What if you did Secretary of State, comma, for state and local verify, comma, for state and local elections, comma, citizenship, all registered. doesn't bring in the two-tier structure. You have to infer that.
I don't think it, I don't know if that works. I mean, I know what you're trying to do, but I don't think it. The two-tier is.
I guess the question is whether, given what we have and the limitations that we have, we want to include this added complexity.
It would make me more, my inference of that, if I just stopped at the library and found it, my inference of that would be is they only care if I'm a citizen if I'm voting in state and local elections. Which interestingly enough is exactly the antithesis of what happened.
Can I,
That would, to me, change it.
can I jump in?
Yes, please do.
So, the hesitation I have with adding for state and local elections only to a specific place is that the text of the constitutional amendment in subsection 5 specifically says, if federal law allows, this requirement shall also apply to registrations to vote in federal elections. So, meaning like the ID requirements, the documentary proof of citizenship, et cetera. Now, granted, federal law may or may not allow that right now. That's kind of what I'm getting at with the unknown. But if federal law changes,
Federal law
then
doesn't
it's
allow it right now.
right. But if something changes, then this is no longer accurate of what is going to be for the voter. So that's the only hesitation. If you want to put something in that relates, that says that this would apply to state and local, I think you just have to be careful, because I don't think it's accurate to say that we have to verify citizenship for state and local elections only, or remove non-citizens using documents and government records for state and local only. Like, that may not be true at some point. So that's why we don't get into hypotheticals, because we don't know and we don't want to mislead. So that's my only hesitation. If you want to do something with state and local, it just has to be in the right spot, and it's got to be worded very carefully to not misrepresent what it is doing.
Well, if I'm hearing Mr. Ziegler correctly, his whole point is to call out the fact that this petition is in effect creating a two-tier voting system. That's what I hear you saying.
Or at least the possibility of one,
Okay, so the
which
possibility, but the point is you're
signatories should
calling
be.
out, this could create a two-tier voting system, whereas if we simply call out state and local, that is not the flavor, that's not the message that's coming through. The idea that we're creating a two-tier voting system has enough legs that it should stand on its own, I think. That's a simple statement. But it's also
It's
not
not
a
just-
true statement.
It's not just the possibility, but the likelihood.
I would agree with that, yes.
Yeah.
Based off of the proponent's own literature, it appears to be a likelihood.
Yes.
Is that a likelihood?
There's another chair right there. Come on up.
The board spent a lot of time, careful time parsing, considering what's actually in the proposal and the actual consequences. Whereas starting out with something that's if, we don't know. We don't know what that part will be and how it doesn't conflict with, the Secretary of State's not removing a citizen. A person removed from the state rolls for not being a citizen is not eligible to vote in the federal rolls because they're still not a citizen. I mean, this is way stuff, and it's also this other proposal last month, you didn't put anything about, well, this could create a two-tier proposal.
I'm sorry, the other proposal, what?
There's nothing in the summary approved by this board last month on the other citizen-only voting that said, well, this might create a two-tier voting system. I just think when you have a task of 100 words, and maybe we should get the legislature to amend it and give you more
The
room,
other proposal didn't create a two-tier voting system.
then it requires citizen-only voting to vote in the state. Well, that's it. If you have
The other
citizen-only to vote in the state, and you have to prove it, then anyway, the main point is, when you say if, how can something that's an if go in a summary? any summary on anything. This might happen, that might happen.
Right.
It doesn't belong there.
In terms of Mr. Fracasse's point, that you don't know what's going to happen, but you do know that unless something happens, this creates a two-tier voting system. It does it now, and you're going to have the two-tier voting system unless federal law changes.
And I might phrase it this way, this might be a helpful way to think about it, which is, currently, I am not aware of anything in Michigan law, whether constitutional or statutory, that could lead to a two-tier voting system. All of Michigan law is cohesive. It's an on and off switch. Either you're a voter or you're not a voter. This petition would create the possibility of that. So this would be a new thing in Michigan law where voters could accidentally, without being informed of it, create a new two-tier structure. And I think that's a distinction because it's not an intangible if. It's something which did not exist before, will now exist, which is the possibility that some people will not be able to vote in state and local elections.
That's a whole lot of lawyerly words.
No, but it's not, and my quote is that it's not a possibility but a likelihood. No, it's a certainty that there's a two-tier system unless there's change in federal law.
I would agree with that.
Yeah.
Yes.
So that's the issue that,
Well,
that does seem pretty important.
that's not, the argument he was making is
I'm
that,
sorry?
the argument he just made is that we've gone from where it wasn't a possibility to where it is a possibility, and not that it's a certainty, and I don't agree that it's a certainty.
I think my argument would stand as I stated it. I would
well,
not like it restated.
I repeated it, I didn't restate it. It's if.
I have nothing else unless the board has a question. Or thank you.
Don't wander too far.
You don't want to help us anymore?
Mr. Brewer.
So on this point, subsection 4 clearly requires the Secretary of State to make a report every year on the distinguishing lists. It states it positively and affirmatively. It does not state it as a hypothetical. This proposal anticipates that there's going to be two lists. Otherwise, why would it require a report about those two lists? The other thing I would point out to you is that you're now debating a summary for the petition. You can revisit this issue if they submit enough signatures and it gets on the ballot. But as I've listened to this debate, I believe the summary has to disclose that this is going to create a two-tier system of registered voters in the state. They said it in their petition. They didn't say possibility. They said it.
So is tier the right word? Is there another word that,
I was going to recommend something different because that doesn't suggest to me, like, if I'm even sitting here, I'm struggling to understand what it means to say two-tier voting system. Like, I don't understand that phrasing. Like, I think the idea is to get at this fact, kind of circling back to the earlier discussion, the idea is to get at the requirement that we essentially would have to maintain two separate voter registration databases, essentially. One for state and local, one for federal elections, is basically what I think is the argument and what this may require. I don't think calling it a two-tier registration system is quite precise enough to really get at that point, because that doesn't.
It's really way too confusing.
That doesn't get at like what it does to me. And I'm not sure if I'm a voter looking at this, I don't know if I would understand two-tier.
no, I agree. The wording on this one is, you have to be very careful because this could mislead a voter quickly. And you're not really decoupling the federal and,
And I'll just point out something will have to be cut then. So if we want to add it in, that's fine, but then I need to know what does the board want to remove?
But
And then I can maybe come up with
It's
some.
correct that here in section 4, it specifically requires the Secretary of State to distinguish between any separate list of individuals eligible to vote in state and local elections or in federal elections. So there is an explicit recognition.
I would phrase it more of that way. Instead of calling it two tiers, like phrase it more with what is in there, because I think that's a little clearer. Yeah, and if that's something we want, what I would recommend is what is okay to, like, what is the thing that we want to remove? And then I can try to wordsmith and provide something based on what we're wanting to remove.
Instead of using the word remove, how about compress?
That's fine too, right, but I just mean, we're at 100 words right now, so something's gotta give, because I can't add, right? So that's what I mean, like, what's gonna give?
You could get rid of the words by showing. It's implied that if you're going to present a birth certificate or something. Fifth line down, citizenship by showing birth certificate, passport, and/or other documents. You could simply require proof of citizenship.
You could do using, saves one word. Via. Right, it saves one word.
You could say with instead of by showing.
With. I think the idea, the reason I use showing was to represent that the voter has to take some action. So I would suggest probably like using or something like that to kind of keep in line with that. The voter has to do something. Still saves one word, but.
Okay, so I think if you said, well, I think this documenting citizenship and voter rolls is pretty important. I think that that's 5 words. If you said, for state and local elections require Secretary of State verify citizenship of registered voters. That, I would put it, I would put it in front of require, for state and local elections require.
Well, they're calling it out the receiver vote because right now for an absentee ballot, you can request it. You're going to have to follow through on this just to request it.
Yeah, I understand that, but I'm just saying, like, the process of to-vote absentee, everything, you know, kind of all encompassing, like, people know what it
Yeah,
means to
that's
vote
fine.
absentee. I know we spent a lot of time on it last time, but that would, if you changed that, you'd save 1, 2,
Let's get rid of 3 words.
get rid of 3 words. If you did that, I guess it's more.
What Paul saying is if we take out the to receive or vote an absentee ballot and simply say, simply make it to vote absentee.
I know we worked on that a lot last time, but if you really wanted to save some words, I mean, that entire process, most people who vote absentee are aware of at least what that process is. And you could say to vote absentee, and that would save you quite a few
Get rid of
words.
some words, yeah.
I think most people understand what that process is if you're doing it.
How many words can you, to express the new context, to express the dual lists, how many words do you need?
Why don't, if you wouldn't mind, if we take a recess and maybe I hear that you want to figure out this, give me some time and we can
We will,
wordsmith,
It's 5
remove.
words, so we'll give you 5 minutes.
I feel like my time is getting shorter and shorter. This is going on.
we're going to take a 10-minute recess. Meeting stands
10 minutes or 5 words, but this is helpful, because it really is. The idea of having 2 lists.
That's a better way to put it, yeah. Any other way you put it is either we're going to have to go with Mr. Ziegler's long explanation, or you're going to have to,
But it's not happening
that's
unless
that's the tricky part.
But it makes more sense in 2-tier.
no, I don't understand
Well, you know what, that makes it so confusing for so many. I mean, I can see people interpreting two-tier in.
I did think about that if we just hyphenated everything and then slashed everything, you could have a very long.
Because the citizenship modifies the voters, it doesn't.
Yes, exactly, exactly. I did think about, I did think about that. Just
Wait, I was just trying to, I'm sorry, what? Oh, yeah, that kind of.
if you put create two voter rolls, it acts as citizenship.
So. It's gonna be really hard.
No, I have, I mean, I'll take it. Stupid computer.
And we're at 96 words. Oh.
I'll say I got it. That. I'm not, that's just what was provided. I'm not guaranteeing I can make it, to be honest. Right. I'm going in the back room. I need to.
Great minds coming together. That's my photo.
We have what I hope is a final draft here. Would you like to read it?
Of course. I'll read it first and then kind of say what I changed and why. So it's Constitutional Amendment 2, require Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and maintain separate voter rolls for federal and state/local elections. Prohibit counting ballots from voters with unverified citizenship unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. Require state-funded hardship program for obtaining required documents. Subject violations to $1,000 fine and/or up to 5 years imprisonment, and that is 99 words. So I added the documentation in. I removed the document citizenship piece that we had in there. Previously, we had document citizenship in voter rolls. I moved that up and coupled it. So the first clause is all of the things that is required of the Secretary of State. So it's require the Secretary to verify citizenship, document citizenship, remove non-citizens using governmental records, and maintain the 2 separate voter rolls for the respective elections. And then everything else is more of what's on the voter. Or like the local clerk, for example, with prohibiting counting of ballots, like those pieces. So I was able to save some words there just by moving those up and kind of combining that first clause into making that all secretary focused, and then removing the other stuff by putting it up there. So that got us to 99 words.
Comments?
I think it sounds just right.
You're good? Sure. You would.
So I guess my first question may be a rhetorical one. I want to make sure that we're all working from the same language in the petition. What is the basis in the petition for this new language? What provision or section are we talking about that requires adding this new language about 2 voter rolls?
I would say the basis is that that if this passes, it will require different verification procedure. It would require different eligibility requirements for state and federal elections.
So
You've included it in, you have it in paragraph 4 here.
So unless federal, I think as we've clarified, unless federal law changes, we're going to have 2 separate systems.
So if it's paragraph 4 of the petition that's sort of animating this, that's a report that the Secretary of State is sending to members of the legislature. There's no requirement that you maintain 2 separate voter rolls. So it is inaccurate to say that you have to have 2 separate voter rolls for state and local elections and federal elections. I understand the sort of the potential inconsistency that there might be in terms of registering. I think there's an easier way to get about that change if we go back to the previous version of this. The clause that begins with, for new registrations, because that's what we're talking about here, it's for new registrations in state and local elections, you have to identify or present documents of citizenship, whereas that might not be the case in federal elections. Again, that's a hypothetical. We don't think that we should be even contemplating hypotheticals, but if we are going to add language, you can just add the phrase, for new registrations in state and local elections, or state/local elections. I think that satisfies this.
I don't think it does, because it's going to be applicable to all voters.
But only in state and local elections, and that's the point that the
Right,
gentleman
so
that was just up here.
It's applicable to all voters in state and federal elections, and that's why in state and local elections, and that's why you have to have 2 lists.
No, well, you don't have to have 2 lists, but it's only for new registrations in state and local elections that you require proof of citizenship by showing birth certificate, passport, and other documents. That's true and accurate.
No, except it's not, because in the new registrants are, with regard to going forward, the new registrants are in no different position than the existing registrants, because in state and local elections, they're all going to have verified citizenship.
No, they're already registered. And so the question then will become, is the Secretary of State verifying whether or not they are a citizen using documents in government records?
If the Secretary of State doesn't verify, then they can't vote in.
If they verified that.
In state and local elections.
If they verify that they are not a U.S. citizen, then yes, they are removed from the voter roll. But unless and until then, they continue to vote, subject to the provisional ballot that we've discussed earlier. But what we're getting at here is a tweak to the registration process that is a potential inconsistency with federal law. Again, that's potential. We're talking about potentialities.
It's not potential, it's accurate. Right now, if this passes, that's what we're going to have, is inconsistent state and federal law, which will require 2 lists.
But just in the registration process, in
No,
what you need yes, in what you need to present in order to register to vote. In Michigan, for state and local elections, it will be you need to provide proof of citizenship documents. Under federal law, assuming that there is no change in federal law, it would be, you can fill out your affidavit of citizenship. So that's the potential inconsistency, but it's only for those who are registering to vote after December 18th, 2026.
Or who are not verified by the Secretary of State.
But those would be people who are already registered to vote, and then when they're verifying, they're verifying whether or not you are a U.S. citizen using documents that the Secretary has access to that are not documents that the individual
If they're
voter.
not verified, it doesn't mean that they're not citizens. It just means that they're not verified yet by the Secretary of State.
Correct, and the only way that they'd be removed from the voter rolls is if they've determined they're not a U.S. citizen.
But they may be unable to vote a regular ballot if they're not verified, even if they are citizens.
Through the provisional ballot process, yes, but that's has nothing to do with the potential inconsistency in the registration process, which was the whole point of making this last tweak.
I can maybe help with this a little bit. So I think there's a couple of things. So if we're talking about just what is the basis for the 2 separate lists, subsection 3 in about 8 lines down specifically says, removals can be made from the list of individuals eligible to vote in state or local elections at any time after the requirements of this subsection are satisfied. And then continuing on, removals arising from the citizenship verification program can be made from the list of individuals eligible to vote in federal elections at any time. So that does suggest to me 2 separate lists as well, with the insertion of the word "the" before it. It's a definite article, and then having it broken out to say the list to eligible to vote in state or local versus the list eligible to vote in federal elections. Coupling that with the subsection 4 language that just says distinguishing between any separate list of individuals eligible to vote in state and local elections or in federal elections, reading those 2 to me does suggest that there is this requirement on us, on the Secretary of State, to have and maintain a state and local registration list and a federal registration list.
Well, what subsection 3 is referring to is this 90-day deadline that can or cannot be excused through federal law. That's the only difference between that and being able to be removed from eligibility to vote in state and local elections.
Right, but I think the 90-day deadline is different from what this is doing. The 90-day deadline is under federal law as well that says you can't remove from a federal election. And even looking at that, the specific says, like that language says, eligible to vote in federal elections at any time more than 90 days before a general or primary federal election. So again, I don't take a position on whether or not the board wants to keep this in or we want to take it out. I don't take a position on that. I am simply just trying to provide guidance on, as I read the petition as it's presented, that is the language that I would point to support why I drafted the summary I did.
I think what you've done on the summary, exception to how you're presenting it, sir, but I think what's been done on the summary is a fair way to put it in front of Michigan voters who you're asking to sign this petition. I think to play to what you're saying is, the road that you want to go down is a much more complicated road. So we feel like we have to put it into this 100-word summary. But I think that the way that you're describing it is, we're not going to weasel word it again.
Just to be clear, my proposal was adding 3 words to the summary, but I understand
I
the
felt your
board's.
words made it more confusing to me to understand.
Well,
I think you've got to, yes, sir. You may certainly have a second.
My name is Paul Jacob.
Could you spell that?
Jacob. I'm chairman of Americans for Citizen Voting. I think there's, maybe we're not all on the same page. There is a law that was passed in Arizona that requires people to show proof of citizenship when they register. That law was litigated, and there was an agreement made between Arizona and the federal government over what to do. To suggest that if this law were litigated, the same result would happen is not only not certain, I think it's wide open. But there's another issue here, which is, I think there's a supposition that this is caused by the Secretary of State looking through all these voters and checking their citizenship. That's not what Arizona has done. Arizona requires that proof when you register. Our proposal requires that. So does the proposal you approved a couple weeks ago with none of this discussion. And it seems to me that if it's true that you needed to put this in now, you certainly needed to put it in before. But the truth is, this is speculative. We don't know what a court will do. We don't know what the Michigan Secretary of State or Attorney General will agree to, or what the federal government will say they want. The federal government may say, we're fine with it. It will depend on who's in charge of the DOJ at the time. So the level of probability here is a lot more complicated than I think has been recognized.
I would say we're not Arizona, so that's, I understand why you're mentioning that, but this is Michigan. Okay, so we're talking about Michigan today, and I agree with you that the probabilities and all of the arguments and all the potentials and the futures and the maybes is what we've mentioned before. This will end up as something that is litigated. For the people who you're going to present this petition to, the way that they have added in the dual roles or the dual lists, I think completely fairly reflects what we're talking about here. I don't, the voters are not going to take this to a probability level, and they're not going to worry about somebody else.
This language says that we are requiring the Secretary of State to maintain 2 separate voter rolls, and that isn't accurate. But the other part, I'm not bringing Arizona in on a whim. The certainty that this is going to require 2 voting rolls is all based on litigation out of an Arizona law. And it's not litigation where a court came down and said, this is what you have to do. It's litigation where the state of Arizona and the DOJ reached an agreement. So that's not some sort of precedent that is just a slam dunk. So the reality about whether there'll have to be 2 voting rolls, I think that's a very open question. And what we're saying in this proposal is if that happens, then of course they have to look at both of those. This is looking ahead and just making sure all the bases are covered. But nothing in this proposal could be said to require the Secretary of State to maintain 2 separate databases. And if that were the case, of course, the petition that you approved that made no mention of any of this does the exact same thing.
The petition that we approved last time did not affect already registered voters. We were worried about that. We understood that it did not affect registered voters. This petition affects all registered voters. And that is why it is totally distinguishable, and why we spent so much time distinguishing it. Now, what you say about Arizona, and I have not read the case, but you say that in Arizona, they just required new registrants to provide proof of citizenship. So does your proposal, but it also imposes this other really draconian requirement that the Secretary of State verify everybody's citizenship, and then where that doesn't happen, then the people have to vote provisional ballots. So that's a huge, and, it requires everything to be different,
Well,
including.
I recognize some people are going to see that as draconian. I see it as the best thing since sliced bread. But it isn't, all the predication of, oh, we're going to have 2 lists has nothing to do with the Secretary. Nothing stops the Secretary of State from checking voter rolls and removing non-citizens. They could do it now if they had the will to do it. We're requiring them to do it. But that has nothing to do with 2 separate voter rolls. That's not where the controversy was. The controversy was on registering to vote. And so I'm just pointing out that it is the same in that regard. It's precisely the same as the previous petition.
If this were put into place today, if we could make a magic wand and all the people in Michigan signed it and they had the election tonight, tomorrow morning, would the Secretary of State be required to have 2 lists?
No.
I'm hearing 2 different answers to that, though.
No.
I'd be curious.
I don't think there's any question. Someone would have to go to court to require that, even if the courts were to be of that mind. There's nothing in this requirement. If this passes and it's not litigated, or it is litigated and the other side doesn't win, there's nothing that requires two voter rolls.
Okay, practically speaking, if the election were held tomorrow and this were in place, 2 lists would still result.
I don't think so. I mean, they could. I understand how it could, and we don't have a crystal ball. We don't know what agreement might be made between the parties. We don't know what court, what judge, whether it goes all the way to the Supreme Court. So we don't know. It is a possibility. I certainly wouldn't deny that. But of course, that same possibility is there any time you require someone to show proof of citizenship when they register to vote. It has nothing to do with the Secretary of State checking. We love the Secretary of State checking, but that has nothing to do with this, with having to have a separate federal-only voter roll.
Can I ask, in section 4, it actually says, so not later, I won't read the whole thing, but not later than January 31st of each year, the Secretary of State shall submit a report to each member of the legislature summarizing, and then it goes on to say, okay, and the number of individuals whose citizenship was verified under the Citizenship Verification Program, distinguishing between any separate lists of individuals from the state qualified voter file, including any separate lists for individuals eligible to vote in state and eligible to vote in state and local elections or federal elections. I mean, this separate list is coming from your document. This isn't anything that, I know you're trying to distinguish what we did last month, but this is, these words are coming directly from this document that we've been reading.
But let's look at those words. Any list. If there is any other list, if in the future Michigan is forced to have 2 lists or agrees to do it in some court case, which is again all speculative, we don't know what will happen, then this covers it because it says any. It doesn't say in the future when you have a separate federal list, check that list as well as this list. It leaves it open because it recognizes, look, law is churning and changing every day, and we want that in the future to not allow someone to say, oh, I don't have to check this one list over here. So it says only, it says any for a reason, because any list that there could be that's a federal-only list, any list that's a state and local list. It does not say you have to have a separate state and local from federal list. And if you read the 100-word summary, it says we require the Secretary of State to maintain separate lists. She'll be forced to maintain separate lists no matter what the federal government says according to the wording of that summary. And I think it's inaccurate.
She will be required to have a separate list. As you said with Arizona, you would have a separate list of people who register with proof of citizenship or without proof of citizenship, because you're not required under federal law to register with proof of citizenship. So you're going to start with that, but you're going to have that, and you're going to have it to a greater extent here than in Arizona, because it's applicable, excuse me, to new registrants and to existing voters where the Secretary of State has not completed the verification process.
It won't have anything to do with the Secretary of State's checking. That's allowed in every state. We only mandate it, but that doesn't trigger it. It's the having to have that proof, because the federal form that they've established, states don't have to use it exactly, but they've, in this court case, they agreed you have to allow people to vote with just checking that box, taking them for their word that they're citizens. And then in that court case, they agreed to keep a separate list, because that's the only way they could keep the verification for the state and local.
That's the point.
This body is assuming the litigation is going to go the same way if this is passed and there's litigation. We don't know there'll be litigation. We don't know how the litigation will end up. And it seems to me to suggest that this measure is requiring the Secretary of State to maintain a second list is just factually not accurate. Now, there may be a different way to say it. I still think it's all speculative. And it really doesn't have to do with the other petition, but of course, this particular aspect is one of the things that's exactly the same with the other petition. That's the only reason I bring it up. But it has to do with the voter registration form. It doesn't have to do with checking citizens as a whole and in checking the entire voter list.
You have 99 words, so you've got one extra word. You could put the word potentially, or you could put the word in front of the word maintain.
I have a question for our attorneys, or Adam, whomever. I know that this is, I certainly understand what you're saying. I guess my question is, as you read this, you would have to be the ones that implement this. As you think about the implementation of this, do you believe that as you implement, that you would need to either have some sort of separate voter roll, or maybe just, confirming eligibility status for a state, federal, local election? I don't mean to put you on the spot. I know that that's a lot. But I'm curious as to actual, the implementation of this. Do you feel that would be a requirement as you implement what would be required of the Secretary of State's office?
As I'm reading it, just as this is now, I do think that there would have to be some sort of distinction. I don't know exactly how we would do that, like the specifics, because that just has a ton of variables with just programming, et cetera. But as I read just the plain text of this, I'm looking at the list of individuals eligible to vote in state or local elections. I'm looking at words like that. The word "the" is really striking to me. And I'm seeing the separation in the plain text of the constitutional amendment that really has this separate dichotomy between state and local elections and the requirements for removing folks from that list versus requirements to remove folks from the list of individuals eligible to vote in federal elections. So that tells me that the amendment does contemplate some sort of separation between the two. Again, kind of going down to 4, kind of saying the same thing. If we have to report to the legislature, quote, distinguishing between any separate lists of individuals eligible to vote in state and local elections or in federal elections, that again has a separation to me, to mean that there has to be something. I mean, if we weren't required to separate it, why would we be required to report to the legislature on it? Coupling that with that other language. This language was not present in the prior one. There was no separate
No, there was
list.
not.
There was no separation like that language is present here. So that, to me, you know, I mean, words matter, right? Like, so that's in my mind why I am inclined to say there has to be some sort of separation. I don't, again, know what, but
And I guess I agree with you, and as I'm listening to this, you know, maintaining separate voter rolls, I think that's a pretty strong statement, because that's not necessarily what you would even necessarily, you could probably check eligibility status in the same voter roll, right? Potentially.
I don't know one
Yeah.
way or the other sitting here, honestly. I think that would really just depend on a variety of factors.
You would have, if you have different eligibility requirements for state and local elections and federal, there is going to be the requirement that you're distinguishing between those two groups of eligible voters, and that's going to be a distinction that is going to have to be made in the polling place.
Could I speak to that?
Yes, please.
There is there are no, you're not allowed to vote in federal elections if you're a non-citizen. Now, there's certain mandates that you not check in Arizona where they had this specific litigation, but you're not allowed to be a non-citizen on federal rolls. That's already, so there's not a different requirement. There's not and in fact, if you look at the U.S. Constitution, Article 1, Section 2, it says that the requirements to vote in all federal elections are the same as to vote in the largest chamber of your legislature. So it's not a matter of there being different requirements. The only difference is that this one bit of litigation said it's good enough for someone to just check the box. So even in Arizona, they could go check everybody's, and if they found you to be a non-citizen, they could take you off the rolls. It's not a difference in requirement or you know, what you have to be or who you have to be, and that's set at the state level. It's not necessarily set at the federal level.
So, but you have to distinguish between people who've satisfied two different requirements. I agree, you know, I agree with you that federal law says you have to be a citizen to vote. Michigan law says you have to be a citizen to vote. So this whole thing is a useless exercise. But apart from that, you know, just to be frank about this is an extraordinary amount of effort devoted to finding the 2 or 3 people who may have mistakenly registered to vote. But you're having 2 different eligibility standards. And so if you have 2 standards, you got to have a way to break them down. You're saying, but don't have to have 2 different roles. Maybe you could do.
What I'm saying is there's not 2 separate eligibilities. There's no disagreement that if Michigan says, you know, that you can't vote as a non-citizen, you can't vote in federal elections either. It's the registration process that's at issue, and that's why the bigger check of everybody who's already on the rolls doesn't implicate anything that went on in Arizona in this one particular case, which is being treated as certain to determine every other case.
Verification.
I understand your arguments. Adam, I also understand that practically speaking, today, the interpretation of this would require you or the Secretary of State to maintain separate lists. I don't know if there's a different word you want to use beside maintain. Mr. Cordes has raised the question of, do we call them voter rolls? I don't know what else you would call them.
So the only reason I used voter rolls was because I think that that's a little bit more common speak for voters. I'm not wed to that. I mean, one option I think you could get at if you wanted is to say maintain separate lists. You could use the exact text from the constitutional amendment petition itself.
Word rolls with the word lists.
You could do that, voter lists. I mean, I think there's other things you could look at as well, but I mean, if the concern is just what should we do with voter rolls, the only reason I put that is just because I thought it was a little bit more specific than the word list, just as to what we're being, what is this getting at? So, and it tied with, we have to track the citizenship status and everything in the what we call the qualified voter file, but I don't think the average voter is gonna know what the qualified voter file is.
So if we use
Could
the
you
word-
just, oh, sorry.
If we use the word lists, which, as you just pointed out, is the same word that you were using in your petition, we use the word lists instead of the word rolls. Is that still conveys to the voter or to,
Could you just say maintaining eligibility for federal and state local elections? I mean, that's really what, I mean, you're doing that anyway, right? Like you are, no, whether this does happen or doesn't happen, really, it's just a matter of eligibility, right? So if you're maintaining someone's eligibility and if there's a change in federal law or state, whatever it is, then eligibility will change. So really what we're just talking about is eligibility, how you track it or what separate list you have. I don't know how you guys will end up doing it, but really it's a matter of maintaining someone's eligibility status, right?
I actually like that.
Separate eligibility lists.
What I would suggest is, and something like, and getting rid of maintain separate voter rolls for, and then replace it with something like, track eligibility
Yeah.
for federal and state/local.
Yeah, I think that's cleaner and less,
track and
Track
track
eligibility
eligibility
For
for,
federal and state/local elections. Or maintain whatever.
maintain eligibility, track eligibility, I don't think it.
Eligibility track.
No, either maintain.
gotta either be maintain or track.
Take
I do think that might be a little bit more precise as well.
Yeah.
For federal and state/local elections.
Adam, would you read that clean sentence back?
Sure. Constitutional amendment to require Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and track eligibility for federal and state/local elections.
Yes. Does that work?
I don't think it does because they're always tracking eligibility for federal and state and local elections. So the point is that it could be different, right?
I think that's my argument for why that would suffice, because say for federal and state/local election and local elections in the event that it was necessary, we've got the. When it says track eligibility for federal and state/local elections, where it kind of signifies that there may at one point be a difference between federal and state/local.
Yeah, you could use the word separate.
But again, there's no difference in the eligibility from a legal
There is,
standpoint. There's a difference in the way it's checked, or the way it's established, but there's no difference in the eligibility.
You could do track separate eligibility requirements for federal and state/local elections, and that would still be 99 words.
You know, I might just offer, I think using the language from it, because I would argue that this is only speculative if there's a separate list. You guys see it differently. Obviously, people can see things differently. But using the language that's in there makes a lot of sense. That's why eligibility is a good word, because eligible is in there. Anytime you say it's a separate list, then you are saying this petition will require you to keep a separate list. And I don't think you can find anything in this petition that requires you to keep a separate list.
About the voter who registers to vote pursuant to the NVRA, doesn't provide proof of citizenship, and doesn't provide it to the Secretary of State. That voter can vote in the federal election, but not in the state. Isn't that true?
No, that voter will not be able to vote in the state election. That voter will be.
And if that voter can't vote in the state election, but can vote in the Fed,
That voter can't vote in any election until they establish that they're a citizen, because it's been, from checking, they can't find that they're a citizen, or they have some suspicion or evidence that they're not.
But this is a new registrant, because that's what you're talking about with regard to Arizona. The new registrant registers in accordance with the NVRA. That voter says, yes, I am a citizen, but is not required to provide documentary proof. If that voter does not provide the documentary proof to the state, can't vote in the state, but can vote in the Fed.
They won't be able to vote in the federal election because they're not registered to vote in the federal election. The Secretary of State will keep one voter roll, I think, and obviously they're free to keep as many as they want, but with one voter roll, they will check. And if that person who registered without showing proof of citizenship is found that, we can't verify their citizenship, then they will be stopped from voting. And not only in state elections, but in federal elections.
But what you're saying is that you don't even need the SAFE Act. You're saying, aren't you? Because you're saying.
Well, I'm not here to argue for or against the SAFE Act.
Okay, but you're saying that the proposal recognizes that there could be a different federal standard, that federal law may change. But you're saying it doesn't matter if federal law changes, that right now, if the person doesn't verify the citizenship when they register in a federal election, they can't vote in the state election. You know, maybe this is just going.
Different point, just for the election director. I think in the semantics of lists and rolls and whatever, and I'm just thinking that in terms of, you have a computer record, and it says Joe Jones, S, state and local, F, federal. I mean, and I know you don't know how it would be implemented. I'm just saying, to me, that isn't a separate role, and it isn't separate list. It would be one list of names with one or two designations.
That's why I think that the best language is what we've suggested with TRAC's separate eligibility requirements, because that kind of gets at the point that you have to have two specific separations.
Let's do this.
So-
Let's put
Yeah.
that together
Could we-
in the writing, and
Yes.
let's.
Could you use the
print
word
it, and then
maintain?
Let's move it to a vote.
Yeah.
We've got other business yet to do
Yeah.
this afternoon.
Could you use the word maintain separate list, or maintain eligibility, maintain instead of track? Does that? Track, make it sound like
Well,
you're
we
following
just went
somebody.
through the-
I would keep with TRAC because it's.
Very good.
Yeah.
You've had a long day. I'm not going to make it longer.
No, that's fine. It is not, I just think TRAC is more accurate, so that's my main rationale.
Thank you very much.
We're just going to stand in recess for 5 minutes while we get this done.
What is my password? That one, okay.
sort of. Whatever you wish. After the business, after the vote, right? Okay, so I just wanted to point out some recent testimony in the elections.
Mr. Chairman.
Richard, I'll see you later. Bye. It's good. No, you're right. A few weeks. Okay, I'll talk to you guys later.
We are reconvened. I would ask that one final reading of, ask that Adam would do one final reading of the 100-word summary.
Sure. Sure, okay. So, Constitutional Amendment 2 requires Secretary of State verify citizenship of all registered voters, document citizenship, remove non-citizens using governmental records, and track separate eligibility requirements for federal and state/local elections. Prohibit counting ballots from voters with unverified citizenship unless voters show documents to Secretary within 6 days post-election. For new registrations, require proof of citizenship by showing birth certificate, passport, and/or other documents. Eliminate affidavit alternative for voters without photo ID. Require photo ID or driver's license or partial social security number to vote absentee. Require state-funded hardship program for obtaining required documents. subject violations to $1,000 fine and/or up to 5 years imprisonment. And it's 99 words. I don't think I need to get into the why. I think that's been covered pretty good.
Do we have a motion? Oh, you want to speak?
No. I'm ready to move it.
Oh, you are? Oh, that's great news.
I move that the Board of State Canvassers approve the summary of the purpose of the constitutional amendment sponsored by Americans for Citizen Voting Michigan, as drafted by the Deputy Director of Elections and presented by the Deputy Director on May 16, 2025.
Second. All in favor?
Aye.
Motion passes. Moving on. Item number 4 on the agenda is the consideration of the form of the constitutional amendment submitted by Americans for Citizen Voting, Michigan. This is actually on the form of the petition. Each member's been given a copy. This has been looked at by elections.
Yes, all of that's correct. This has been posted on our website as well. So as normal, what we do with the form requirements, when staff is reviewing the petition form itself, we are just looking at the size of the document, et cetera. Our review does not extend to the specific text of the petition itself, the specific language in the proposal. The only thing we're looking at on the back side of the proposal itself is it the right size? And are the elements that have to be there present? So staff has reviewed this. It does comply with the requirements.
Meets your requirements, and I think we have a request from.
Yes, just a point of clarification or additional request in communicating with the staff about the form of the approval form. We inquired whether we could put sequential numbering on the ballots to ensure that we can track them. And we were told that we're not allowed to do that, but we can use a QR code or a barcode as the board has approved in the past. And so with our request to approve the form, we'd like that to be to confirm from the board that it will not invalidate the approval of the proof of the form if we add the barcode or the QR code, and that it will not be considered a disqualifying factor for the petition form during the approval and sample process.
Can I respond? So to be clear, you can use a sequential number. The question was asked was about the specific location of it. Sequential numbers are fine. We typically do not require they provide that with a copy of us for the form stage, because that changes, right? It changes with every single petition, and it's not a mandatory element under election law, so that's typically where the board has not required that. So if circulator groups want to use a QR code, a track number, what we always ask is that it not be in the upper right-hand side of the petition, because that's where we put our stamp. And if it goes there, it causes us a lot of problems with processing. So we always recommend that it goes somewhere along the bottom. A barcode would work, like a printed barcode we've seen. The thing that we always caution against is to use a sticker of some sort, because if you put a sticker on and it covers up a mandatory element, anything on this page, that entire sheet is invalid. But relevant to this, we don't typically require that tracking element at the form stage, just because, like I said, it changes. We view it as more of like a function of the group and not a role for us.
So with all of the expensive legal horsepower in this room right now, I'm going to give you the most valuable piece of free advice. Will you, if you're going to put an identifier on there, will you make up a copy exactly how you plan to do it? And will you make sure that Adam and the folks at elections get it before you go to press and print out 100,000 or 200, right?
Yes, we will.
I will also emphasize, sorry, and you, please, I didn't mean to interrupt.
Do you want him to do that before we approve the form?
No, because we don't need it to approve the form.
We just
can
wanted
approve
assurance that if we moved ahead in light of the guidance that we received from staff, that it wouldn't be a disqualifying factor if we added that after the approval process.
I'm not sure what you're asking of us.
He's just verifying that he could put the identifier on here later. It doesn't need to be on here for us to approve the form, and Adam, you're confirming that. And I'm
Consistent with
simply
board
suggesting
practice.
before you do
Yes.
it, just make sure you bring in a copy of the real deal.
Yeah, the next step for here, just as a reminder, and just for anybody that's not aware, the next step is the board has obviously approved 100 words. That has to be replaced. Section 483A of election law requires an additional 15 copies of the as-circulated version to be filed with our office. If that does not happen, any signature that is gathered is automatically invalidated. So we have to have an as-circulated version prior to any group being allowed to start circulating. It's usually at that point, that's when we get the barcode or something like that on it.
You have an enormous
Understood.
resource with these folks, and they will help you make sure it's in exactly the right spot.
Well, thank you. We appreciate it.
Before we do a motion, I think Mr. Ziegler asked if he could speak for a moment. And you have to keep it really short for me, okay?
Very brief, very brief. So this board obviously knows it usually grants conditional approval subject to that 100 words being swapped out. And there is some examples where they do not grant conditional approval, and that is when the 100 words needs to be swapped out and when there are typos in the text of the amendment. Here, Article 2, Section 1, Clause 4 has the word WOHSE, which, of course, is not a word, it's a typo. Article 2, Section 1, Clause 4, fourth line down on the right-hand side.
Oh, yeah, WOHSE.
You know, we did refuse to approve the form of an amendment, of a petition, when Member Daunt
Brought up typos.
noticed that there were typos.
Did we refuse to approve it, or did they withdraw it? They withdrew it, and they presented it at the next meeting, I believe. Is that correct?
Do you remember
I've-
whether, I know,
I have a
That-
transcript in front of me, if that would be helpful.
I'm sorry?
I have the transcript in front of me. It was the September 23rd, 2021 meeting with Secure My Vote. And board members Matuzik and Bradshaw both said, I'm going to vote no. This is not the 100 words that we usually do. These are 100 words. These are typos. This is an error with the printer's affidavit. Fix it all and bring it back.
Okay, so none of us were on the board at that time, but I do recall Member Daunt, with a, discerning eye, found some typos in a petition, and either they withdrew it, as you point out.
They withdrew it and
You think
brought
they
it back.
withdrew it as opposed to our rejecting it?
Well, and that brings up another point here. I'm just going to ask this for clarification, because I asked it last time when we had this come up with Tony's. The wording as it appears on this petition, if this is gathered signatures and it's blessed, is the exact word, the wording can't be changed. This would be the exact wording in the Constitution then, correct?
Correct. At this point, I mean, you can change it, but you have to start the process over.
No, I
right?
get it.
But yeah,
The point being is if this were approved, and we're setting it up so that this misspelling would then carry through,
potentially, yeah.
potentially.
I don't know the exact of how that piece of it works when it goes to, I don't even, LSB maybe that does it, but.
And this is why two members of the board, so I believe it's correct that the petition was withdrawn, so there was no formal vote of no. But two members of the board did express, I will vote no. This is on page 88, lines 8 to 18 of the transcript. So I think there is sort of a soft precedent of the board that where there are typos within the text of the proposed amendment, the board does not approve or conditionally approve until they see a clean copy, which is the words that Board Member Matuzik repeatedly
Our
uses.
conditional approval in the past was conditioned only upon substituting the approved 100-word summary and not conditioned upon correcting typographical errors.
That's right, not to any change in the text of the amendment.
I want to just jump in and answer a question that was asked. So at the September 23rd meeting, I'm just looking at the meeting minutes right now. Obviously he's got the transcript as well. What the minutes say is there was no motion made on it, so the board did not formally adopt or reject it. It said the sponsors will submit a revised petition to be considered. So I think that they did, based on that, I think that they withdrew or said, we'll withdraw this item, to be clear, just the form piece, and then come back. So,
Am I
for what it's
under the assumption that if we proceed forward with a motion, you're not, let me rephrase that. I'm going to ask the petitioner first. Do you want the ability to withdraw this petition and correct it and bring it back in June?
I guess my answer is to that is a question, which is we would ask that it be conditional on us substituting not just the summary, but also that word.
The summary we have already moved and approved and gone through. The summary, if I'm not misspeaking your process here, the summary is already done. If you withdraw the body of the form and you correct it and reschedule to come back and put it on next time's agenda, that would be a separate vote.
But my response to that would be if we're able to make the approval conditional on us substituting one portion of the petition, we'd ask that you make this, by the same logic, allow us to replace that one word and replace it with the correctly typed word.
There's another typo. But, so I would suggest it's not just one word. I don't know if your argument's going to be the same, but, well, I'm not trying to withhold it. I didn't mark it on this one that I have, so I saw it a couple days ago. I can email you if you want, but.
Okay, and I think what we did recognize when Member Dawn brought this to our attention was that it was not our job to correct or conditionally approve with regard to typographical errors. Our condition would only be with regard to substitution of the approved summary. So,
I can't speak for my fellow board members, but rather than do this on a conditional basis, I really would like us as a board to see the revised copy before we vote. Is that fair?
If the board's policy is we're only making our approval conditional on the replacement of the summary language, then our position would be we'd like to withdraw the petition and bring that back, item number 4.
Your summary's been approved. No one's going to touch that. This has to be corrected, though, or otherwise it will go to, if you want us to vote on it now, I can pretty much guarantee what'll happen. So you will withdraw this, and you'll correct it and then bring it back? Okay. All right.
Want to make clear, just for the record, we're talking about withdrawing as for approval as to form only, correct?
Yeah, correct,
I see
yeah.
nods, and so I'm going to say yes to that. Okay,
Summary stays in place.
thank you.
Moving along.
Moving along.
Item number 5. Thank you, Mr. Ziegler. Item number 5, we have consideration of the proposed de minimis modification to voting system Dominion Democracy Suite 5.20 -ECO number 101025. And let me pull it open here. Will you summarize what you're looking for it too, aren't you?
Yes, I am just also trying to get myself organized among the paper I have as well. That is this one. Okay, thank you. So this is a proposed de minimis change to the Dominion system. Essentially, it would replace a computer monitor for the EMS system that's at the county level. The current monitor, in layman's terms, is just not being made anymore, so we need to update it to have a new one. The current monitor has reached its end of life state. I was looking for confirmation to make sure I'm using the right words. So this de minimis change, again, it's gone through the EAC, it's gone through a voting system test laboratory already. So this de minimis change is essentially just to replace that, the Dell P2425H monitor with replace the P2422H monitor with the P2425H monitor.
Any questions? Need a motion?
I move that the Board of State Canvassers approves the use of the Dell P2425H monitor as a display device for server and client workstations due to the Dell P24228 monitor becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Aye. Item number 6, consideration of the, let me sure I'm on the right line here, hold on. Consideration of the proposed de minimis modification to voting system Dominion Democracy Suite 5.20-ECO, bound 101046 and ECO 101047.
So this is also a de minimis change. This is just essentially two different components, so we put it together. But again with Dominion, de minimis change that's gone through the EAC as well as ProVNV Vistal Test Lab. The component, same situation, we're at end of life with the current. Essentially, it's the Ethernet network switch which connects to the EMS system, and to swap it out to have one again that we can have versus the old one which is now at an end of life again. So the two that we're looking to replace, it would be a 24-port Ethernet switch, and we can kind of see in the memo kind of the reasons why, as well as a 8-port Ethernet switch for both components. So, and again, both are just the current version is at end of life.
I actually looked those up for you online and ran the back tech on those, so yes, you are. And there's even a security improvement in the new ones.
Yes.
Do I have a motion?
Yeah, I move that the Board of State Canvassers approves the use of Cisco 24-port Ethernet switch C1300-24T-4G due to the Cisco CBS 350-24T-4G Ethernet switch becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
All in favor? Oops.
Support.
There we go. All in favor?
Aye.
Aye. Number 7, consideration of the proposed de minimis
I need a second one. Yep, there's a second motion as well before we move on to number 7.
Oh, I'm sorry.
It's
There were two.
separated.
Yes.
Forgive me. You
Yeah.
know what? They were together. My
They are
mistake.
together,
Forgive me.
I think.
I move that the Board of State Canvassers approve the use of Cisco 8-port Ethernet switch C1300-8T-E-2G due to the Cisco CBS 350-8T-E-2G Ethernet switch becoming commercially unavailable for the Democracy Suite 5.20 voting system in the state of Michigan.
Support.
All in favor?
Aye.
Number 7, consideration of the proposed de minimis modification to voting system Hart Intercivic, Inc., Verity Voting 2.7, ECO 01679.
So this is another de minimis, similar to the ones with Dominion. It's a different piece of equipment. So this is essentially the rollers on the tabulator. On all of the Hart system tabulators they have reached end of life and are now also commercially unavailable. What's a little bit different with this one is because it is a new, it's a new roller, it's a little bit of a different material, so essentially it will require a patch update that Hart will begin programming with the affected counties, jurisdictions, and the affected equipment. Essentially, and the reason is because it's a different material, the system just needs to calibrate, essentially, is the word I'm going to use, with the ballots and the ballot size, the material, et cetera. So again, this has gone through the EAC, it's gone through ProVNV, I'm sorry, not ProVNV, SLI, for testing, and they've also concluded, again, de minimis change. So happy to take any questions.
Anybody questions? Do I have a motion?
I move that the Board of State Canvassers approve the length adjustment due to page scan 4 scanner rolling end of life for the Verity 2.7 system used in the state of Michigan.
Support.
All in favor?
Aye.
Aye. Concludes the normal business. We have other business presented to the board, and I think we do have some.
Yes, I have lots of updates. Well, not lots, but I have several updates. So first, I want, as some of you may recall, we did engage in rulemaking about a year ago, I think, at this point, for procedural rules to the Board of State Canvassers, as well as the recount rules, to update our recount rules, largely in response to some of the things. The recount rules were in response to some of the statewide recount that we saw in 2022, for example, and the procedural rules were largely timing and just kind of cleanups. Those were filed with the Department of State this week, meaning that they are now in effect. We will be sending them out to the members of the public so they're aware. We will post them as well. The biggest impact with the procedural change is the requirement that people have to submit materials to the board at least 48 hours before the meeting, and that materials received less than 48 hours before the board meeting will not be allowed to be considered. We will get that out, but it is our intention that when we get something very last minute, that we will not accept it. I won't even pass it on. And I will respond and say, we're just rejecting this filing. It does not prohibit people from speaking. It does not prohibit members of the public from attending the meeting and testifying in support, opposition, just providing general public comment. It does not prohibit individuals even from reading from something if they want to bring like a letter and they want to read their letter. It doesn't prohibit any of that, but what we were aiming to go after was, if you recall with the nominating petitions, when we were in May/June of 2024, when we had to have a separate meeting, when we were still getting literally 5 minutes before the meeting started additional challenges on petitions and rebuttals, and during the meeting we were still getting emails. So it's meant to kind of prevent that from happening, to allow some sort of finality, to be frank, before we come to the board meeting. So like I said, those are in effect. They will, and we'll put them out so the public knows, and we'll send them to the usual mailing list that we have, that we send the same materials to.
Welcome rules. That was a difficult time.
I do have a question for you. So if this letter that we received less than 48 hours ago would have been a classic example of something submitted that would not have been brought to the attention of the board.
That is correct.
So here's my question. I understand the 48 hours material will not be considered. And when we dealt with this before with nominating petitions, it was over challenged signatures, had to go back to be verified by the QVF. The letter that we received less than 48 hours ago was an information letter. For you not to act on it as Bureau of Elections, I get it. But I have a different question. I'm concerned that we as a board should still be able to read it if we chose to.
Okay.
Is that within the guardrails of what's been set up, or is that at our discretion?
It's within, I mean, I can pass it to you as the board. What the rule specifically says is that members of the public shall submit material to the board at least 48 hours before the meeting. The board shall not consider material received after the 48-hour deadline. So you can pass it. I can still give it to you. There's not much flexibility with the word shall for that reason. And that's also partly why we are aiming as a bureau to push back our notice requirements as well. We've been posting agendas and things like that no less than 4 days before the board meeting itself. So that way there is time for that. Same with like summary language, things like that. Staff reports are required to be posted 3 full business days at minimum. We usually do at least a week before the board meeting for that, for some of these reasons as well. So if we get it, I can pass it to you. I think you do have a little bit of restraint where if something comes in of what your limitations are, but that's where I would say that an individual that wants to do that, 1, get it to us before the 48-hour deadline, but 2, they can still come and speak to it. They still can come and say, I want to testify, and here's the materials that I want to testify on and speak to it.
And I'm not suggesting that we would bend the rules on something like, for example, what we went through with the judge where the signatures kept coming in.
Right.
That's not even in my question. My question is more that if somebody submits a letter, if it's for information or if it sheds light, the sister question to this is, I've been approached by a couple of folks who have asked, why are we not putting public comments on the website prior to the meeting? So if we've received public comments, why are we not posting those for people to read? And I'm not sure that's a legitimate question, but I'm asking it.
The main reason that we haven't been posting, that we typically don't post public comment on the website is because the public comment we get comes from a third party, right, a member of the public, things like that. And we just don't want to release anybody's PII, essentially, their personal email or anything like that. If they're submitting something to us collectively, whether it's the Bureau or the Board of State Canvassers, there's still that expectation of privacy, that yes, it's public comment, yes, they're testifying, but so we try to keep that back. If it's something the board wants us to consider, I'm not opposed to it. I think I would want to be clear, because especially in instances where, like you'll recall the last petition that we had over 400 emails roughly, give or take a couple hundred. That gets a little burdensome to go through and have to redact every single person's information. So I would just, I think there would be that balance if that's something that we want to consider.
We'll noodle on it for a while. Yeah, I think we'll for that. You good with that?
Yep.
All right. Just, we'll come back to you with that one.
Okay. I was gonna, okay. So that kind of leads me actually nicely to a couple of other things if we're talking about the website. We are working on just kind of updating the board's website in general to just make it a little bit more user-friendly. We're working on getting some things out in just different ways to make it easier for both us and members of the public. And one of those things that we're working on is actually kind of a little bit more of like a branding element for the board so that things can have a very unique design. So we'll be bringing in future, we'll be bringing some stuff, options essentially. We've talked about this before about doing more like videos or things like that. So this is just an example of things that we're trying to kind of have a more unique look to the board as well. So that's just kind of a update. I don't have anything yet, but when we have it, I'll keep you updated, as well as when the website changes too. So that might be a good time to even circle back to that to see what's
What we want to talk about.
yeah, what's an option. So not for today, but next meeting we also are going to be presenting you with an updated copy of the petition manuals. As you might recall, we try to go through these at the end of each cycle. At this point, we are not proposing any change to the process. Right now, there's a couple of things we're going to clarify with the manual and the examples, and I think we're going to end up breaking them up into different versions. So it'll be like a statewide ballot question versus a candidate, just to provide a little bit of clarity for people, is one of the things we heard at the last cycle. So we are working on that. We're going to present those to you. My intention with that first was to ask if there was anything that the board process-wise wanted to change. I haven't heard anything since the last cycle, but I wanted to just double check. From here, we are intending on posting it and sending it to people to get public comment as well to present at the next meeting. But before we did that, I wanted to make sure that there wasn't something I've missed, that the board is like, no, start doing this or stop doing this, something, and if there's anything like that. I don't need a firm answer on that. I mean, we can obviously circle back to that at the next meeting, but.
I'm not sure if this is processed, but we had that lingering issue with regard to verifying the signatures of the circulators on, yeah.
That is part of what we're going to present to you as well. We have taken everything that we've done with the West investigation and have tried to basically reduce it to writing. So that way we've got a clear, if this, then this. If you do this, this is what we need in order to kind of be sufficient, like a sufficient standard of proof, for lack of better terms. for us to commence an investigation. And then if we do that, this is what our steps are gonna be. And then if you don't do that and kind of have that step by step, so we are gonna present that as well. We'll again post it online, but it was our intention to present all of that as one package. If you think of anything, I guess, in between, let us know. Yes.
Yeah, the one thing that I had suggested and that I think you're working on is having the announcements a little more prominently displayed.
That's part of the general website overview. Yeah, so I'm looking at different ways to just make it clearer, like what's coming up on the meeting versus like a lot of the documents we have on our website are for like just resources for people, right? Voters, circulators, et cetera, petition candidates, sponsors, et cetera, of everything. So just to kind of delineate that a little bit better, that is one of the things we're working on.
Action items.
For lack of better terms, yes, where it can be a little bit like upcoming meeting, here's what's going to be discussed type stuff, versus just, that is, yes, we are working on that. And then the last thing I want to update on is the West investigation. Yeah, I'm reading my notes to make sure. So we had intended to present a staff report to you today. The reason we didn't was largely because there is one circulator that we are attempting to get more information from. Largely in our review, and we will present this at the next meeting for sure, a staff report and with a request or a resolution, whatever. Largely overall, our review has concluded that there was no significant indications of widespread fraud like we've seen in others. As normal, there's a couple of signatures here and there that were determined not to match. There are some circulators that we still have not received information from. I believe there are 5, if I remember, thank you. 5 circulators where we just haven't gotten anything from them. And then there was one circulator that we have received, where we received a driver's license. It was an out-of-state driver's license, and his signature does not match the signature on the petitions. None of them. The signatures on the petitions all match each other, but they do not match the exemplar that was provided to us. And again, our standard of review with this is it's all reasonable doubt, right, when we're verifying signatures. So what we are doing now is we are attempting to reach out. We have referred it to our Office of Investigative Services for assistance. I shouldn't say referred it, but we've reached out to our Office of Investigative Services to get some additional assistance to try to get a hold of this circulator. It's not clear to me whether this is fraud or whether this is a difference between the license and your regular signature. And the reason for that is all of the petition circulator sheets, all of the sheets that this individual signed in the petition drive, they all match each other, but they don't match the license. So what's unclear to me at this very moment is whether is the license signature outdated, and again, because it's out of state, I don't have a way of telling whether it's a year old or 20 years old. I don't know that information. So that's kind of what we're trying to get more information on. We're trying to get some more information on whether this was this individual that actually signed these and the license signature isn't the most accurate, or is this something else? So it is our intention that we're getting close to to exhausting all remedies at this point. So at the next meeting, we'll have a presentation, we'll have the staff report, we'll give you examples, we'll show you kind of what we saw with the examples so you can kind of go behind us, for lack of better terms. And we will either have a resolution to this one way or the other, or we would be asking the board to take some other step. Michigan election law does contain a number of options after this that we are allowed to seek, so that's what we would be. If we can't get information, or kind of, it'll depend on what the resolution is, but we will be asking the board to vote on something or to vote to close it, or some other action. So I didn't feel I could present that in a staff report today because the staff report is the final step, right? It's the final resolution. And I'm not prepared to say that this is or is not fraud. I don't know one way or the other. So, and we're just attempting to take all reasonable steps to reach that resolution. Yep.
What's the Office of Investigative Services?
Sorry, that is an internal office within the Department of State. That's the office we work with to, they, relevant to this board was the office that we referred all of the previous circulators and signatures to be referred for criminal prosecution. So they help us with just basic investigations and things like that. They have a little bit more resources to be able to find people than we do, so that's why we looped them in to see if they were able to help us out a little bit more than we've been coming up with.
All right.
I think that's all of the updates I have. I know that was a lot, so.
Oh, no, I appreciate your updates. Those were all, we wanted to know about every one of them. Is there anything else to add to anything from the AG's office?
I was just sitting here trying to remember if the board is currently being sued, and I don't believe so. So let's enjoy that window while we have it, but.
Feel ignored, or should we?
Not at all. No, there's plenty of other problems in state government, I assure you.
If there's no other business to be brought before the board, I would say that we will adjourn the meeting. And we will adjourn it at 3:45.